give you a mic check. Mic check, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Good morning, sir. How are you? Good morning. If everyone could take a seat, hopefully in the center of the room, so that folks who come in late can have a seat as well. Good morning. My name is Stacy Shore, and it is my honor to welcome you to the 5th Annual Conference of the Citizenship and Immigration Services Ombudsman. As you may know, we listen to your feedback. And this year, we have live streaming, so those of you who cannot join us in person can learn about how the Ombudsman brings together government and stakeholders to talk about immigration benefits issues. Also, have you heard? We're on Facebook. How many of you have liked us already? Thank you. Those of you that didn't raise your hand, when you get a chance, please go ahead and like us. As acting deputy director, I am very proud of what our small and mighty office has accomplished. Before we move into the program, I would like to cover a few housekeeping issues. First, you may notice that we're in a beautiful, pristine auditorium. Thank you to the National Archives for maintaining it. But there is no food or drink allowed in this auditorium. If you need a cup of coffee or a mid-morning snack, there is a cafe at the end of the hall. Many of you have a folder in your hands, and inside is an agenda with the day's program, as well as bios for our speakers. And most importantly, our feedback form. So if you could please make sure that you complete it and leave it in a box or with one of our staff members before you leave here today. And last but not least, on housekeeping, please turn off your handheld devices. It is my pleasure to introduce our Ombudsman, who brings 20 years of cross-sector experience in the field of immigration law. As an INS trial attorney, as a private practitioner, as the executive director of a national faith-based organization, and with this in-depth experience, she makes sure that our work product is not only thoughtful, but well thought out. She encourages us to think outside the box, to be innovative in our product and in our approach. We are very lucky to have Maria Odom as our Ombudsman. She helps us meet our mission with efficiency and empathy. And with that, I would like to introduce to you Maria Odom, the Citizenship and Immigration Services Ombudsman.
Thank you. Thank you. Thank you, Stacy Shore. Thank you. It's very kind of you. I am very proud to serve as your ombudsman. Welcome. Good morning. It's great to be here. It's our 5th conference. Can you believe it? Feels like it was just yesterday when my predecessor, January Contreras, launched this great initiative, and I'm very proud that our office continues to host this conference. I'm glad that we continue to hold it here at the National Archives, surrounded by the beauty and the complexity of our nation's history. So I am pleased to welcome you. I am pleased to welcome our staff as well, who I will introduce in a minute. I am pleased to introduce our friends from USCIS as well. And I'd like to thank Archivist Ferrio for hosting us again, and for his incredible staff. They help us every year with the logistics and the execution of this conference. Thank you, those of you who are helping us live stream today and are helping us throughout the day. It's been a momentous year for immigration. I think one which warrants a special morning discussion on the implementation of the President's 2014 directive to reform our nation's broken immigration system through a series of executive actions. You will hear shortly from our Secretary of Homeland Security, Jay Johnson, and also from USCIS Director Leon Rodriguez, as well as other department leaders who have been instrumental in carrying out this very ambitious task. I know that they're looking forward to some of your questions too. In the meantime, allow me to share a bit about the important business of the Ombudsman's office. As the Citizenship and Immigration Services Ombudsman, I lead an independent office at DHS, which is charged with problem solving. I am extremely proud to be part of a team that works hard each day to do right by those who do not see and experience our immigration services at its best. For those of you who are new to our office, we do two things. We assist individuals and employers in resolving their problems with USCIS, and we review the agency's policies and procedures as we identify problem areas and work with them to propose solutions to resolve them. I'm often asked, what does an ombudsman do? So I'll borrow a very simple yet so on point definition from a fellow ombudsman. He said, ombudsmen are useful people when it comes to making mistakes right. If you complain to an organization and they don't sort things out, then an ombudsman might be able to help. They are the people to whom you can turn for help when all else has failed. Our work would not be possible but for the professionalism, integrity, and grit of our ombudsman staff. They embrace problem solving, they embrace our mission, and they welcome open dialogue with all of you. I'd like for all the folks in the from the Ombudsman's office who are in the audience to please stand. Some of them are outside working. Thank you for your service. I'm very honored to work with all of you. You are one dedicated bunch, and I'm very proud to work alongside all of you. Thank you. But we don't do this work alone. Every day, they work, and we work with dedicated USCIS officers here in Washington, D.C., and also around the country, who share in our goal of providing high-quality immigration services. I'd like to recognize our USCIS colleagues in the room. Please stand. I know you're there. We know you're here. Thank you for all your hard work. Ms. Mariela Melero, Associate Director of USCIS Public Engagement and Customer Services Director. I got all that backwards, Mariela. Welcome and thank you for your support and for your commitment to the work that you all do. Ombudsman work is hard work, and it's often done quietly and very effectively, sometimes even without recognition. And while we need steadfast advocates for much needed comprehensive immigration reform, we also need to keep our commitment to improving the delivery of services in the immigration system that we have today. This is critical. It is critical in part because we have seen a sharp increase in the number of requests for assistance made to our office over the past year. It has more than doubled since I was appointed to this position in 2012. There is still a lot of work to do. Why is our casework important? Because cases not only represent a family, an employer, an individual seeking benefits or relief, but they also signal to new or continuing systemic issues that require the agency's attention. For example, recently, our office noticed a spike in the number of applications for change of status to that of student. Delays prevented some of these applicants from starting classes, from accepting campus employment. Some even faced losing teaching and research positions and fellowships. Given the good number of cases coming to our office showing a trend, we contacted USCIS and they worked to resolve these delayed cases. More importantly, they immediately started working on addressing the operational causes for the delays. In some cases, our office intervenes to address a clear error or quality issue in the actual adjudication of a case. That includes monitoring the use of templated requests for evidence and other notices. We do that to ensure that customers receive adequate notice of evidentiary deficiencies in their filings and an adequate opportunity to address them. Other cases that we've seen this year involved individuals facing delays in renewing their employment authorization documents. While the vast majority of employment authorization applications are adjudicated by USCIS within the required 90-day statutory timeframe, every year, especially in the summer, thousands of individuals encounter processing delays in renewing their work permits. Similarly, over the past year, we received requests for case assistance from applicants seeking to renew their deferred action under the Deferred Action for Childhood Arrivals program. While some had timely filed their applications, they faced delays in renewing their DACA grants and also their accompanying work permits. So we continue to try to understand the operational constraints that prevent the timely adjudication of employment authorization documents, as well as DACA renewal applications. And we encourage the agency to be true to its posted processing times and to recognize the negative impact of a lapse in having a valid employment authorization document. It impacts individuals, employers, their families. On the humanitarian side, next month, our office will issue formal recommendations addressing trends our casework has uncovered relating to special immigrant juvenile policies and procedures. We also continue to advance our mission through public engagement on issues that matter most to those who come to USCIS for immigration benefits. This year, we participated in over 100 stakeholder engagements in 20 different states. And we continued our teleconference program, hosting important conversations, some with USCIS, on important topics, including provisional waivers, many revisions that we've seen lately to USCIS forms, and long-standing problems in the employment programs. But though we are an office charged with focusing on problems, sometimes that makes us unpopular, we recognize USCIS's many successes and efforts to modernize our immigration system and also to implement the President's executive actions. I don't want to steal Director Rodriguez's bragging rights later. I'm sure he will talk about some of the good work they are doing at USCIS, but I'd like to congratulate him on the agency's much-anticipated L1B guidance and the launch of two very important humanitarian programs, the Haitian Family Reunification Parole Program and the In-Country Refugee Parole Program for Central American minors. And I also commend the agency for its planning and preparation to implement the President's executive action initiatives. Before I close, I'd like to share that in addition to my role as the Citizenship and Immigration Services Ombudsman, I also have the privilege of serving as the chair of the DHS Blue Campaign. The Blue Campaign is the unified voice of the department to combat human trafficking. The campaign was created on the idea that we are at our best only when we are all working together to fight the crime of modern-day slavery. This year, the Blue Campaign celebrates its 5th anniversary. That's 5 years of raising public awareness of human trafficking, 5 years of working with our government and private sector partners, 5 years of training law enforcement, both here at DHS and also around the country, and 5 years of working and coordinating department policy to support investigations and, more importantly, stabilize and provide relief for victims of this terrible crime. I am grateful to Secretary Johnson for his support of our office and for his leadership. I also wish to thank Deputy Secretary Alejandro Mayorkas for his relentless commitment to the immigration work of this department. I'd like to again thank my staff for putting together an incredible and ambitious agenda today, and also like to thank our panelists for what I'm sure will be a day of great conversations, and again, all of you, once again, for joining us for this 5th conference. Thank you. Now, Secretary Johnson has challenged us here at DHS to bring together our talents, our rich experience, and our department's resources into one whole of DHS effort. Now, his vision for unity of effort is reflected in how we have worked together to respond to the President's directive to do what we can to fix our broken immigration system. I am very honored to work under his leadership. Please join me in welcoming Secretary Jay Johnson.
Thank you, Maria, for all the terrific work that you do as our Ombudsman. Thank you, ladies and gentlemen, for being here today. I recall addressing this conference last year and welcome the opportunity to come back here. Let me provide a few thoughts about where we are, particularly with the implementation of our executive actions. Let me begin with something that I said at Westminster College in Missouri in September. I was honored to give the 56th annual Green Foundation lecture at Westminster College in Missouri, in Fulton, Missouri. The most famous Green Foundation lecture at Westminster was given by Winston Churchill in 1946, the famous Iron Curtain speech. In 1954, former President Harry Truman went to Westminster and gave a Green Foundation lecture. His lecture, given during the McCarthy era, the Red Scare, was about what hysteria does to us. I decided in my Green lecture to use that as the basis for my own remarks. At Westminster in September, I said, all of us in public office, those who aspire to public office and who command a microphone, owe the public calm, responsible dialogue and decision-making, not overheated, oversimplistic rhetoric and proposals of superficial appeal. In a democracy, the former leads to smart and sustainable policy. The latter can lead to fear, hate, suspicion, prejudice, and government overreach. This is especially true in matters of homeland security, and it is especially true in matters of immigration policy. At that speech, I commented that I know this both as the Secretary of Homeland Security and in a very personal way from the experience of my own grandfather. I talked about testimony that my grandfather gave before Congress in 1949 to the Committee on Un-American Activities of the U.S. House of Representatives. The lawyers here will appreciate this. This is the Q&A. Question: are you now, or ever have been, a member of the Communist Party? Johnson: I am not now, and never have been, a member of the Communist Party. Mr. Chairman, I have been asked by this committee to state my views as an educator regarding the loyalty of American Negroes. In one sense, it is like asking if Tennesseans, or Presbyterians, or foreign-born citizens, or American women, or persons with freckles are loyal. Where there has been resentment, and this is in the year 1949, where there has been resentment, it has been not against the form of government, but against those who misinterpret or seek to abuse the purpose and power of government and vitiate its cherished freedoms. All of you here know that around immigration policy, there was a lot of emotion and a lot of misinformation. I like to note a poll taken by Pew Research 2 years ago that asked the following question in its survey. 2 years ago, just your best guess, compared with 10 years ago, do you think the number of immigrants entering the U.S. illegally today is higher, lower, or about the same? A majority surveyed, or 55%, said that they thought 2 years ago the number was higher than it was 10 years before then. When in fact, as I think all of you know, the opposite is true. The high of apprehensions on our southern border was 1.6 million in FY 2000. In FY 2013, that number had dropped to 414,000. In FY 14, the number was 479,000, the rise owing primarily to the spike we saw last summer in the Rio Grande Valley of the children and the families. This past year, FY 15, the number has dropped to 331,000, which, with the exception of 1 year, is the lowest number of apprehensions we've seen on our southern border since 1972. Notwithstanding these lower numbers, there is more we can do on border security. As a sovereign nation, we must protect our borders from illegal migration. But as all of you know, building more walls is not the answer. More technology, risk-based strategy, not more walls, is the answer. One of the pieces of advice I got last summer when we were in the midst of the crisis on the southern border was from the U.S. Conference of Catholic Bishops, that you have to offer people an alternative way, hope. You can't put a padlock on a burning building. So we've established in-country processing in Central America so that parents here can petition to have their children come to the United States. We'd like to see wider use of this program. In terms of building a wall, one of the best commentaries I've ever heard from a border security expert was and is, if you think someone is motivated enough to leave their home in Central America, travel north across the complete distance of Mexico and climb a 10,000-foot mountain, are they really going to be deterred by a 10-foot wall? Or, as Janet Napolitano used to say, show me a 10-foot wall and I'll show you an 11-foot ladder. So more technology is the answer, not more walls. There are 700 miles of some form of fence across the southwest border, now built pursuant to the Secure Fence Act of 2006. Longer term, we need to invest in root causes. The poverty and violence in Central America must be addressed, which is why this administration under President Obama has requested $1 billion for Guatemala, El Salvador, and Honduras in aid and investment in those three countries. Today, I want to review with you the progress the Department of Homeland Security is making on our executive actions announced a year ago. Congress has not acted, as all of you know, on comprehensive immigration reform. We are disappointed by that. The Senate passed a terrific bill in 2013, but the House has failed to act. So, the President and I have acted on our own, within our existing legal authority, to do what we can to fix the broken immigration system. Overall, the President's policy, our new policies, are smart, common-sense uses of the resources we have to focus on threats to public safety, felons, not families, quality of our efforts over quantity, giving people an opportunity in this country to be held accountable and to be accountable if they've been in this country for years and have roots here. In terms of the Deferred Action for Adults program that we announced last November, we are disappointed that this important program is in litigation in the courts. We are disappointed that the district judge has enjoined the program and the expansion of the DACA program that we announced. But we will fight on. We will defend the program. We will defend the case in the courts on appeal. We are anxiously awaiting the decision of the Fifth Circuit following in the oral argument on July 10th. Deferred action aside, we are moving forward with the other 9 of 10 executive actions, the most significant of which is our reprioritization of how we use our resources for removal. We're focusing more on felons over families, quality over quantity, as I said, and threats to public safety. The Nonpartisan Migration Policy Institute has noted with respect to our new removal priorities, which we announced last year. These prosecutorial discretion changes, which have received significantly less public attention than the Deferred Action Program, make it unlikely that unauthorized immigrants who would qualify for DACA or DAPA will be deported. The overall impact of the new memorandum is to describe DHS enforcement priorities more precisely and more narrowly than was the case under the 2010-2011 guidance, while broadening the circumstances under which DHS personnel should exercise discretion, including reasons departmental personnel may choose not to deport people who generally fall within the enforcement priorities. Overall, the new enforcement policies, and I continue to quote, have the potential to substantially transform the U.S. deportation system, particularly within the U.S. interior," end quote. So as all of you here know, in fiscal year 2012, ICE removed 409,000 people. Fiscal year 13, the number dropped to 368. Fiscal year 14, the number went down to 315,000. We're still counting, but in fiscal year 15, I anticipate that that number will be significantly less than 315,000. Why is that? Well, first of all, simply there are fewer people on the intake side because of the lower apprehensions, the fewer total attempts to cross the border illegally that we saw in FY15. Second, however, ICE is doing what I told them to do in terms of the reprioritization and the focus on convicted criminals. Of those deported in the period March to September 2015, 83% of those deported in that period are in my priority one for removal, the criminal at the border. At-large arrest of those convicted of felonies and misdemeanors is up 22% from last year. The bottom line of all of this is fewer deportations, but a greater percentage of those are convicted criminals and threats to public safety. That is the direction we want to go. That is the direction the President directed, and that's what we are doing. Other reasons for the lower deportation numbers, frankly, was the politically and legally controversial Secure Communities program, which we have ended and replaced with the Priority Enforcement Program. As all of you know, under the Secure Communities program, municipalities, states, counties were enacting limitations on their levels of cooperation with Immigration Customs Enforcement, leading to a number of detainers that were not acted upon, including detainers on people who are convicted criminals and threats to public safety. We are changing that. With our new Priority Enforcement Program, we have replaced detainers with requests for notification on a defined list of crimes and removal priorities, not simply going after people who have been arrested or convicted of minor offenses. We have received a good reception so far to our Priority Enforcement Program. Of the approximately 340 non-cooperating jurisdictions that were out there, nearly 2/3 are now working with us on the Priority Enforcement Program, and this is a work in progress. Of the 25 largest, which account for 83% of previously declined detainers, 15 of those 25 are now working with us again. More will be coming online soon, including big cities, and the preliminary indications are that the individuals being transferred under this new program fit within my priority one for removal to an increasing percentage. We are doing these things for public safety. So, in terms of our other executive actions, let me announce and say again, as I've said several weeks ago, we have issued a proposed rule to expand eligibility for provisional extreme hardship waivers of the 3 and 10-year bars to all persons who statutorily qualify for that waiver. The comment period for this change is closed, and we are now reviewing the 600 comments we received and are preparing to issue the final rule. Second, and to encourage broader use of this waiver, on October 7th, we published new guidance for public comment on the extreme hardship requirement. Up until now, no clear guidance on what extreme hardship means was out there. For decades, there has been confusion and inconsistent application. This guidance will provide the needed clarity for this benchmark. The comment period on this guidance is open until November 23rd. We encourage all of you to send us your comments in reaction to this proposed guidance and help us publicize this guidance once it is final. Third, on September 25th, State and DHS made changes to the visa bulletin to enable certain families to apply for green cards sooner. Fourth, we have almost completed guidance to assist the families of those defending our country in the U.S. military to obtain work permits. On October 15th, we provided public notice of a proposed rule to strengthen the program that provides optional practical training for students in STEM fields studying at U.S. universities. On May 26th, we finalized a new rule that allows spouses of highly skilled H-1B workers to apply for a work authorization or an H-4 visa. We're working on a regulation now and guidance to support high-skilled businesses and workers by enabling these businesses to hire and retain talented foreign workers while providing these workers with increased flexibility to advance with current employers or seek new opportunities elsewhere. Additionally, we are working on a regulation to enhance opportunities for foreign inventors, researchers, and entrepreneurs wishing to conduct research and create jobs in the U.S. We're promoting and increasing citizen access to citizenship under the leadership of Director Rodriguez, who will speak next. During the week of September 14 to 21st, we launched Citizenship Week and Constitution Day, and USCIS, in that 1 week, naturalized 40,000 people. And we're now permitting payment by credit card of the naturalization fee. We continue to assess a partial fee waiver of the naturalization fee, an idea championed by a number of organizations represented here today. In terms of our Deferred Action Program, as I mentioned earlier, the DAPA program is enjoined, but we are defending the case on appeal, along with the enhancements and enlargements of the DACA program. We are defending the case on appeal. We will continue to fight for this program. To those who say we did not have the authority to create the DAPA program without a change in law, I say, well, then you should change the law. We must account for these people. We must encourage them to be accountable. They are not going away. We are not going to deport a population of people the size of New York City and Chicago put together in anybody's administration. There are sound and good law enforcement reasons why we should encourage deferred action. It is also, in my judgment, simply the right thing to do. There should be no second-class people in this country. The most striking thing about this population is something like over half of them have been here for 10 years. They live among us. We know them. They work among us. They study among us. There was a documentary on a couple of weeks ago on PBS Frontline about immigration reform, and I suspect a lot of people here saw it. I'm proud that two of the people in that documentary, Esther Oliveria and David Shahulian, now work for me as immigration and legal advisors. Esther had a couple of bit parts in the documentary. I had to watch it twice before I noticed Esther sitting behind Senator Edward Kennedy at the beginning of the documentary. It was kind of hard to recognize her. It was 8 years ago. Her hair was a little darker then. But it was the speech in which Senator Kennedy announced the end of the effort then at immigration reform. And he said then in 2007, and I quote, "This is a message of hope. Hope for those of you who recognize the need for immigration reform and deferred action. It is now clear we are not going to complete our work on immigration reform. This is enormously disappointing for Congress and for the country, but we will be back and we will prevail. The American people sent us here to act on our most urgent problems, and they will not accept inaction. I have seen this happen time and again. America always finds a way to solve its problems, expand its frontiers, and move closer to its ideals. It is not always easy, but it is the American way. In that vein, let me tell you something that my grandfather, who had to testify before the House Un-American Activities Committee, said in 1956. This is a man who had to testify and deny he was a communist before our Congress in 1949. In 1956, a month before he died, he wrote something in the New York Times Magazine about a Southern Negro's view of the South. This is September 1956, before the Civil Rights Movement had taken off, before the Civil Rights Act of 1957, before the Civil Rights Act of 1964, the Voting Rights Act of 1965, and all the other things that have occurred since that time. He died a second-class citizen in a train station in Louisville, Kentucky, in October 1956. This is what he said about the African Americans' plight in the South in September 1956, very much in line with what Senator Kennedy had to say in 2007. It is variously expected that Negro Southerners, as a result of their limited status in the racial system, would be bitter or hostile, or patient or indifferent. Bitterness grows out of hopelessness, and there is no sense of hopelessness in this situation. However uncomfortable and menacing and humiliating it may be at times, faith in the ultimate strength of the democratic philosophy and code of the nation as a whole has always been stronger than the impulse to despair. So to those of you who champion immigration reform, fixing our system, and caring for those immigrants who are in this country seeking a better way, I say that the road is long, it can be bumpy, but in the end, we always do the right thing. We always get there. The arc of history is long. So for those of you who work with Maria, who want to build a better system and build a better life here for immigrants, very much. I'm sorry I can't stay and take questions. I do have to get back to my palatial headquarters uptown on Nebraska Avenue. But thank you all, and I hope you have a good conference.
Thank you, sir.
Thank you.
Thank you. Leon, are you ready? So Leon Rodriguez, the director of USCIS, is a colleague who joined us here at DHS over a year ago, and he probably feels about 10 years in experience to him at this point. He assumed an incredible challenge, but also, I think, the amazing opportunity to lead USCIS in executing the President's directives on executive action. It's a pleasure to work with Leon. It's been a pleasure to watch you run with that incredible charge and watch your staff over the past year, pre and post injunction, to work to make that happen. And I appreciate USCIS's partnership. I appreciate the incredible commitment of your staff who work with the Ombudsman daily to help fix problems that sometimes require everyone's attention. And I appreciate that we all share the same goal of making the system better. So please join me in welcoming USCIS Director Leon Rodriguez.
Good morning, everybody. It's good to see a lot of familiar faces and some new faces. So since I have a little bit of extra time, you're going to indulge me because it means that I get to tell a couple of stories. And I'd like to start by talking about how I go to work every morning. I live in Montgomery County, Maryland. Probably a handful of you here do as well. And over probably the last 8 or 9 months, I have made a habit of passing through the corner of University Boulevard and New Hampshire Avenue on my way to work. Those of you who know the area well know that to be Langley's Crossroads. And the reason I go through there is because I realize that in my mind, I do what I do for the people of Langley's Crossroads and people like them all over the United States and all over the world trying to get into the United States. Because if you look at Langley's Crossroads, it is an amazing melting pot of people from all over the world. You see Korean supermarkets, you see Salvadoran restaurants, Indian restaurants, you see African clothing shops. It's really a mini United Nations. What you also see every morning at around the time that I go through is crowds and crowds of people going into the metro, crowds and crowds of people lined up at bus stops, all really working to pursue their little piece of the American dream. This morning, that route was ill-advised. Not because it wasn't yet again inspiring to pass through Langley's Crossroads, but rather because the traffic was horrific on the way downtown via New Hampshire Avenue and North Capitol Street, and that gave me time to think. And time to think is sometimes a little uncomfortable. And it was uncomfortable because I started thinking about the meeting when I saw all of you last year. And that would have been just a few months after I had become director of USCIS. Maria was kind enough to facilitate my discussion with you. And you asked a number of questions about a number of matters. And what I don't know is how well I have done in the past year in resolving the issues that you raised. And that calls to mind really a second thought. I have been in government for most of my life, and I have grown through that time to become very interested in the behavior of organizations, whether they are government organizations, whether they are companies, whether they are nonprofit organizations, and have grown interested in what makes organizations act, what makes organizations change, what makes organizations improve. And actually what we do in USCIS is a very interesting case study in that sort of question. What makes an organization move, improve, and change? We're a very large organization. We're 18,000 people. We have an annual operating budget of approximately $3 billion if you take into account all the fee accounts. And so we're not necessarily the most easily movable object. I view my job as director to make wise and smart decisions about how the organization moves and changes as it moves forward into the future. And there are a constellation of inputs that go into how those decisions are made. Obviously, there are a couple of fixed points. One is our basic annual budget. Even if we do a fee revision, the basic size of that will be the same. The basic size of our workforce will probably be about the same. So that those are, in and of themselves, pressure on what we can do and how we can do it. But then there are a number of other forces that act on us to make us change. Two of those very important forces are in this room right now. And so as stakeholders of different type, a number of you are immigration lawyers, others are advocates, others play other roles in our system. Oh, thank you. I'm audible though, right? Yes. Okay. So I'm gonna eventually start walking around, and then I'm gonna walk off with the microphone. So as I hear from you, that in fact has a very significant influence in how I make decisions as a director. And particularly when I hear something from you not just one time, but when I hear things from you 1, 2, 3, 4, 5, and 6 times, that starts being a signal that somewhere in that 24-hour day, I'm going to have to find an hour to actually do something about that issue that you've raised. That means that we've now hit a certain critical mass. Another critical actor is sitting right in front of me, and that is Maria Odom and the Office of the Ombudsman. They play, I think, a very, very critical and very special role. Actually, I think that probably most government organizations should have an institution like the Ombudsman. And that is because they are built-in resistors to inertia. So they have a very specific charge, one, to facilitate correct outcomes on cases, to act on behalf of our customers in cases where the system may not have worked, or certainly where those customers are not satisfied with the outcome, and then to also look for opportunities to systemic improvement. They have done so, I think, in a very constructive, very orderly, very thoughtful, very evidence-based way, and I'm really grateful to them for playing that relation. I'm also being in that relationship with USCIS. I also want to congratulate them on the work that they've done in the DHS Blue campaign in combating human trafficking, which is something that is near and dear to my heart. So I do that all to really set the stage to say this is a very important interaction, which in little strokes and little strokes and little strokes will actually in fact, eventually has the outcome of modifying the work we do based on the reality of what is happening to immigrants out there every day. Now, I want to talk for a little while longer, give you some updates that you'll probably be interested in hearing. Actually, the Secretary did a good job of sort of giving you the outline of what I'll be discussing in detail. And then I'd really like to open to questions. And questions for me are, when I open for questions, it's questions, comments, concerns, whatever the case might be. Let's dig in first to where we are with respect to executive action. And I want to, for those of you who don't know her, she's not here today, but I just want to introduce you indirectly to an individual by the name of Jennifer Higgins, who actually was supposed to be on your panel this afternoon. She has served since the inception of the executive actions as my senior advisor on the executive actions. She was then and is now dual-hatted as the Deputy Associate Director for the Refugee Asylum and International Operations Division of USCIS, and in fact her role will now be sort of multiplying geometrically because of our increased targets for refugee admissions. So I just wanted to let everybody know about her leadership role. Unfortunately, she's not able to participate in the panel for which she was scheduled today, but I'm still hoping that all of you get the opportunity to get to know her. The way I've seen the executive actions, there are basically three key pillars to the executive actions. And they really speak to the three sort of key ways in which our immigration system has been, take your pick, brought to improvement, as the case might be. So the first of those is, as the Secretary discussed, taking the first steps towards some sort of permanent resolution to the condition of undocumented people in the United States. This is another one of those, we're just talking about how institutions move. There will never be enough public will to remove 11 million people. Nobody will want that enough. Many people, of course, don't. And nobody will ever want to spend the kind of resources to do that requires. Meanwhile, those 11 million people are not just 11 million people. They are husbands, they are sons and daughters, they are sisters and brothers. They are quite typically part of communities that in fact contain United States citizens, contain legal permanent residents. And so the impact, were we to actually go down that road of 11 million people, is not an impact on just those individuals alone, but in fact would have a devastating impact on families, on workplaces, on communities, on institutions of faith, all of which would be terribly, terribly undermined were we to make that decision. And meanwhile, at the same time, whether we admit it or not, many of these folks are actually contributing quite substantially, both economically and in many other ways, to our society. The most sort of notable, most obvious example is the DACA recipients, who anytime you pick 20 of them to meet, you'll find young people who are studying, who are working, who are building families. Some of them are telling us, if you give us a shot, we'll join the armed services so that we can serve our country. A perfect case study of people who in many respects are actually still on the margins of our society saying, notwithstanding that fact, I'm ready to participate. I'm ready to come in and to make a difference. So we had taken the step of instituting the DAPA and DACA extension programs. I think everybody has a good understanding of where the legal process is with respect to those initiatives. We are now, I would call attention to this, we are now 3.5 months past the oral arguments in the Fifth Circuit. In circumstances where 2 out of the 3 judges who heard the case were the same 2 or 3 judges who had heard our appeal of the denial of a motion to stay, had issued very promptly a decision. All facts worth noting as we think about where this process stands and when and how we will have the opportunity to stand up these programs, which we believe were not only legal, but more importantly, or as importantly, were good and critical policy to address these issues. But the one thing that I always hasten to remind people when we talk about this, executive action can never have been the end game for immigration advocacy. Executive action needed to be understood, deferred action in particular, needed to be understood the best that we could do given the failure of the political system to act. There is no question that the political system needs to act. It needed to have acted a long time ago to address this issue, and given its failure, we took action. The fact is that everything that is going on right now in terms of the legal process, in terms of a lot of the dynamics of our current election, further dramatize the fact that our country's leaders, I'm one of them, so I have to take this responsibility just as much as everybody else, our country's leaders need to take responsibility as a political system and find a real solution to this situation. So as we churn in court, as we churn in the election, all of that is calling further and further attention. And I do believe that that tipping point will come, and that perhaps that tipping point is actually not as far off as we may fear that it is for this reason. I also call attention to the fact that about 90,000 young people age into DACA every year. We are committed to encouraging those young people to make the choice of requesting deferred action and to take advantage, of those opportunities. As a whole of, I think, in Americans, as particular charge, comprehensive leadership take to get the legal permanent residence. Many of them, LPRs for a long time now, are not choosing to naturalize. And we've learned that we need to really speak very concretely about what is gained through citizenship, what the rights and responsibilities of citizenship are. And we're doing that through a number of means. First is through the Citizenship Public Education and Awareness Campaign. Key elements of that campaign have been launched in the last couple of months. Multimedia campaigns on the internet, in print, and on radio to really talk in very encouraging terms both of the benefits of citizenship, but then also to underscore the resources that are available to people in order to prepare for the civics exam, in order to meet the language requirement, and in some cases also to be able to pay the fee for naturalization. And in fact, we've found a lot of support for our efforts from municipal governments. Just about every major city is interested in some way in advancing immigrant integration, not to mention a number of other middle-sized cities that are really enjoying rebirths in many ways as a result of their immigrant communities. And part of that is being accomplished through what is called the Welcoming Communities campaign, in which we've entered into very strategic agreements with New York, with San Francisco, Nashville, Tennessee, Atlanta, to use municipal resources in order to promote access to naturalization. We've also, as you know, taken the very concrete step of now offering credit card processing to individuals. At this point, the pace seems to be about 2%, so it's still, we're sort of inching up. Our expectation is that over time, this will become a more and more attractive option to applicants for naturalization, especially, I think, when we reach that point where the entire experience is actually electronic. And I think when we reach that point, we're going to see more and more people, one, taking advantage of the electronic tool, but also the option of credit card processing. Additionally, we are very actively, as part of our fee review, looking at expanding fee waivers, particularly looking at the option of a 50% fee waiver for those between 150% and 200% of poverty. So that process is very active. I would, of course, be staying tuned in the months to come, as there will be a number of significant developments in the area of our fees that I think will be particularly important to this community. We continue our work in the area of visa modernization, working closely with the Department of State to update, improve, and clarify immigrant and non-immigrant programs. I know that there's been a lot of back and forth about the visa bulletin. I am hopeful that as we have now issued the October 2015 visa bulletin, that we are entering a period of at least more clarity. That now reflects revised procedures for determining visa availability for applicants waiting to file employment-based or family-sponsored adjustment of status applications. I talked about the waivers before. You're all familiar with the work we did with the L1B guidance. That is meant to ease the process of enabling multinational companies to transfer employees with specialized knowledge consistent with that organization's interests. We've had a lot of utilization of our H-4 dependent spouses employment authorization regulation. As you know, ICE is working on the OPT STEM rule. We continue working on clarifying the availability of the national interest waiver by which foreign nationals in the EB2 immigrant visa category, including inventors, researchers, and entrepreneurs, can take advantage of that waiver. We are working quite actively right now in developing a regulation for parole for certain entrepreneurs subject to certain circumstances. I know that's been an area of great interest. We're hoping to have that as an NPRM before very, very long, as well as a proposed regulation to implement the AC-21 and AQUIA provisions governing adjustment of status processes and employment-based and immigration provisions as well. So those are lots of work going on in that front. I think most of which you'll start seeing coming to fruition in the weeks and months to come. I want to talk a little bit about where we are on refugees. The President, I think, took great leadership by directing us to raise our targets to 85,000 for this year, 100,000 for next year, with a very specific target of 10,000, which incidentally is a floor, 10,000 admissions of Syrians. I've spent a lot of time, particularly since June of this year when I was in Turkey visiting our resettlement center, really digging into the situation in Syria, which is devastating. This is a country of 22 million people. The last I checked, and I have a feeling this number has probably grown even more, 11 million of that 22 plus million is displaced in some way. About 4 million, and that number has probably grown. That number by itself has probably grown. Are refugees now in Jordan, in Turkey, in Lebanon, in Egypt, and elsewhere. Certainly in Europe. And then another 7 million are actually displaced internally within Syria. With the Russian bombing, all those numbers promise to grow yet further, not to mention the devastating loss of life, destruction of communities, disruption, complete disruption of life in Syria, and that will continue to mean a lot for us to do in the refugee and asylum corps. We are working very carefully to make sure that we meet all of our obligations, meaning that we will certainly meet our targets with respect to refugee admissions. A lot of those resources are the same resources it's the same pool of resources that we would use in the asylum world. So we are busy looking for efficiencies to continue to do our credible fear and reasonable fear processing in an efficient manner compliant with the law, to eat away at our affirmative asylum backlog, and also to meet these tremendous challenges that we face in the Middle East. Knowing that as we look at the worldwide refugee situation, there are 19 million people, 19 million refugees in the world right now. So we're not just talking about Syria, we're not just talking about Iraq, but we're talking about Kenya. To some degree, we're talking about the Americas. We really, the humanitarian crisis throughout the world has just continued to grow and grow. I want to thank those of you who in some way, either as individual counselors or as advocates, supported us this summer as we worked to comply with the court's order to retrieve the 3-year work authorizations under DACA and to replace them with 2-year work authorizations. Would that we would never have had to have done that, but the fact that we're able to successfully conclude that effort, we thought was critical to the overall stability and survival of the DACA program itself. So to those of you who supported that effort, we are very grateful. A lot of activity going on the special immigrant juvenile front. During the first 9 months of 2015, we saw a 69% increase in the number of filings. Back in June, published updated guidance on the implementation of the Paris-Olano Settlement Agreement governing special immigrant juvenile adjudications. These are cases, in some cases, that were denied, and the number of cases are being reopened and reconsidered based on that settlement. We have centralized the adjudication of special immigrant juvenile petitions. One of the things that we discovered is that any given place where we were seeing these petitions, we're not seeing that many of them. So we were not developing the level of expertise and depth of expertise in this kind of work that we thought was optimal. We believe that by centralizing this work, that will result in a higher quality of adjudication and also go a long way to addressing a number of the concerns that I know that the Ombudsman has expressed. In fact, that was one of the Ombudsman's specific recommendations, was that we centralize that unit, and a wise and well-taken recommendation. Other work with vulnerable populations is our U visa, T visa, and VAWA work. Important to know that we use supervisory quality review when we make a final decision to deny a petition. These are challenging cases because for those individuals who need them and qualify them, they are essential from a humanitarian perspective that they have access to these visas. But at the same time, there have been concerns of fraud in this program, and so the premium on our doing this work in a professional and thoughtful manner is quite high, and we are continuing to move forward to do this work in the best way possible. Finally, I want to talk a little bit before looking out for questions about the continued importance of combating immigration services fraud, which includes, but is much broader than, the unauthorized practice of immigration law. I actually got to go to my professional birthplace just a couple of weeks ago, to the Brooklyn District Attorney's Office, where Brooklyn, like all the five New York area district attorney's offices, has a crimes against immigrants unit that is combating the sort of notario fraud that we've seen, a number of other scams that are targeting immigrants. We want to continue as USCIS to support those kinds of efforts, to continue putting out information on how individuals can avoid scams, and to generally pull together the combination of government, of the advocacy community, of the legal community, in really making sure that when individuals get immigration help, it is in fact competent and honest help. So I look forward to our partnership on that front as well. I had the opportunity just a few weeks ago to take my children on a ranger-led tour of Ellis Island. And I learned something that I think I knew in the back of my mind, but that was really dramatized by the information the ranger gave us, which was, until 1924, if you were from Europe, you could come to the United States, period, unless you were sick, you were an anarchist, or a criminal. That was it. Those were the only restrictions on immigration in that period. Obviously, we live in a far more complicated world, which is where a lot of the work that we need to collectively do to, one, move toward immigration reform, but two, to do the best that we can do, given the hand that we've been dealt as a system, that continues to be important. I've actually generally become more interested in immigration history in recent months and read a speech given by the then president of the then president of the Daughters of the American Revolution back in the 1960s. And the title of the speech was "Why We Need Immigration Quotas." And one of the arguments proffered for why we need immigration quotas was the prospect that the question of how can we effectively screen refugees who are coming to the United States. Now, this was 1960s. So the refugees that they were talking about were actually my parents, and refugees from Cuba and refugees from other communist countries who were coming at that time, and we were wondering how we could screen them effectively. Well, I think the story has sort of told itself, because the refugees of that era have in fact come to the United States, have built businesses, have gone to school, have really told the story of the American dream all over again. I fully expect that this next generation of immigrants will do exactly the same thing. Meanwhile, plenty of work for us to do, plenty for us to talk about, so I will open for questions. Who's first? That works.
I have a mic here.
There? There we go.
Director Rodriguez, I wanted to ask you about the ability to improve transparency and stakeholder input. My name is Angelo Paparelli. I'm an immigration lawyer practicing with the firm of Stacy Shore. And last June, I asked you that at a public forum, and I urged you, when you do draft guidance, not merely to publish the final guidance, but to let us, the public stakeholder community, see what reaction you had to the comments that were made. You said you'd take it under advisement. We haven't been getting any feedback on the comments that the public makes as to how the agency considers those changes. It would have been helpful with the CIMEO memo. It would have been helpful with the changes to the visa bulletin. And we get that when you publish rules.
Right.
And it's very frustrating to see, for example, the visa modernization proposal or announcement that came out of the President's directive of 1120, 2014. State and DHS didn't give us any feedback as to why certain other ideas were rejected. And what can you do to make that work? Because it's not working right now.
No, I appreciate that feedback, and that's, I appreciate you for being willing to say it a second time. Actually, probably a third time at this point, because I think you said it last year. It tends to stick. I'll point to a couple of things. One, I think you can all appreciate that we are trying to do a lot right now. I think what the President is doing in the executive actions was very, very ambitious. I can let you know that my staff has been working very hard. I think one thing that we have found has been very effective, and it's not exactly what you're suggesting that we do, although I can't see a reason why we wouldn't do what you're suggesting what we do, is we've had more and more stakeholder gatherings as we roll out, whether it's new policies, whether it is, and so that gives, I think, a lot of transparency to what different stakeholder communities think about what we're doing. It gives us an opportunity to give some more feedback. I actually think we probably can do even better along the lines that you're suggesting, at least certainly for the sort of the big policy decisions that we make, to be able to articulate, why we're not doing something. So I said I would take it under advisement, and I'm going to continue to look at ways to do what you're suggesting. I think it's good advice.
Can you hear me?
Yeah.
Hi, good morning. Sorry, I got a little eager to ask you a question. My name is Cecilia Levin. I'm with CISOMB Immigration Assistance, and I want to thank the Ombuds Office and for you for being here today. It's just a really great opportunity. My question is about the U-Visa program, and particularly the problems surrounding the U-Visa wait list. At the Vermont Service Center last year, we were informed that there's 95,000 cases that are pending, 45,000 of which are on the U-Visa wait list. And that currently in this fiscal year, CIS is looking at applications that were filed in some period in 2013.
Right.
And so this causes lots of different problems, but principally one that concerns us is the delay of family reunification for waitlisted principals and derivatives who are abroad. CIS is under a regulatory directive to provide parole to these waitlisted clients, and we have worked with brought this issue to the attention of the Ombuds staff and to others in CIS, and we wanted just to check in on the status of creating those parole procedures, as well as confirming that you waitlisted clients can use deferred action in similar ways that other folks with deferred action, like DACA recipients, are able to use advanced parole when possible.
Yeah, I'm going to ask that we make sure that we fully answer your question sometime before the end of this conference. I know that there's some work that I've been in a few policy discussions exactly to move these options forward. I'm just not sure the status in some of the specifics, so I'm going to ask somebody to make sure that we get that information to the group before we conclude here today. Yep. I know there's one over there. Over there. There we go.
Hello, sir. My name is Jacqueline Ayo Davis. I'm not a lawyer or anything, just a stakeholder. I started a group, Africans for Immigration Reform. I have like 3 different questions. The first one, I heard the secretary talking about immigrants that have been here at least 10 years. There's no way to deport them. So my first question is, if you've been here at least 5 or 10 years, why isn't there an option to self-petition? Why do you always have to wait on either a spouse or a son to petition for you? What if you don't have those avenues?
Yeah, I mean, there are very limited avenues for people. Obviously, there's extensive avenues in the employment context. There are limited options under the diversity visas. That really just leaves the family visas, which that's the legal design of the system. Whether in the future we can talk about a different design to the system, that's something absolutely worth advocating about. But we're basically rest on the legal system that we've been given is what we are administering. I think what the secretary was speaking to was that basically the way that our deportation priorities work, unless you are a recent illegal crosser, or you're a criminal, or you're a threat to national security, then you don't fall within those removal priorities. And I think what the secretary was recognizing that, in fact, if you look at our undocumented population, many of those people have now been in the country upwards of 5 years and 10 years. So I think that's what he was trying to talk about when he said that.
Okay. And now my next question is, if you are a spouse of a LPR, and have already been in the country for that same specific period, why do you have to wait until your priority date comes up to get a visa?
Again, that's just the basic the basic legal setup of the system. It's how it's been structured over a long time.
Okay, thank you.
I know there was one over there. Yeah.
Hi, Director Rodriguez. My name is Margaret Stock. I'm a private attorney, and I'm also a retired military officer. I wanted to ask you about some of the comments that you made in your terrific opening remarks. Not a day goes by where I don't get a call from an immigrant who's interested in applying for citizenship and who is massively confused by the forms that USCIS has generated. During this administration, the citizenship form, the N-400, has gone from 10 pages to being over 20. And there's a new iteration coming out that's 28 pages that asks all kinds of interesting questions that cause immigrants to be concerned that they will not be able to get citizenship, and in fact their green cards are going to be taken away from them if they should take any steps to apply for citizenship. An example, I think pretty much every day I get 2 or 3 Facebook messages from somebody in the military asking how they should answer the question, have you ever belonged to an organization that has tried to kill people? People, and they tell me that USCIS officers at interviews tell them to cross out their yes answer, which, you know, they go yes and they say I belong to the Army. The Army does try to kill people. That your examiners are telling them to change their answer to no because the question, quote, doesn't apply to you. These forms are getting, not a single one has gotten smaller under this administration. In fact, I noticed the other day when I was trying to do a change of address for an alien sponsor, immigrant sponsor, that they have to file 9 pieces of paper with the government in order to change their address now. And 7 years ago, it was 1 piece of paper. Now it's 9. We had a sensing session a few weeks ago with the Ombudsman's office, and we raised these issues, and the Paperwork Reduction Act person was at the sensing session. He helpfully told us that the point of the Paperwork Reduction Act is not to reduce paperwork. It's to...
So what did he say?
He said it was to... This is in your minutes, by the way. It's on your website. He said it's to reduce the burden on the public, not to reduce paperwork. But I was left wondering how the burden on the public is being reduced.
Here's the tension, and this is a dialogue I think we're going to continue to have because I hear this much more in other contexts than I do in citizenship, but I think it speaks to the challenge. We are often criticized for overly burdensome requests for evidence. Too many of them, they're not well tailored, they don't seek the evidence. And so part of the intent as these, whether we accomplish it or not, let me just acknowledge that we need to hear whether we accomplish it or not, as these forms grow and more complicated, is to actually avoid having to go to a request for evidence at a later time. So to ask all the questions up front so we don't necessarily need to end up asking them later on, and also to make things more clear to people. Whether, again, I think we need to have a constant feedback loop as to whether it actually has that effect. But the one thing I can assure you is that the intent is not to sort of make people's lives more complicated. That's also, by the way, why we seek comment on these forms, and in fact do make changes based on the comments that we get, either because it's not understandable, it's not relevant. So I think the feedback is important, and I think something that we have to take into account, but at the same time I want to give you some sense of why I think these forms are growing in the manner that they have. Thank you. Here, you can have mine. Okay.
One of the things when I've talked to examiners, they tell me that they're not offered any opportunity to give feedback on the new forms, that they're being generated by somebody higher up and then sent down and said, implement. And the impact, the second and third order side effect of these longer and longer forms is pretty significant. And it doesn't appear to me that people who are making the decision to implement the forms are necessarily aware of the impact, the longer and longer interview that has to take place versus a 10-page form versus 21 pages. I would hope to make the helpful suggestion that it might be good to perhaps beta test the forms before they're actually rolled out, and that maybe a small focus group attempting to use the forms, watch them go through the agency process, have an interview done with them, see what the glitches are, because it doesn't seem to me that the cost-benefit analysis will fly if the benefit of these lengthier and lengthier forms is supposedly to avoid an RFE.
Right.
You're actually getting worse results on the front end, and you're deterring a lot of people from applying for things.
No, I appreciate both the suggestion and the feedback, and I like in particular the suggestion of beta testing. I know we're certainly doing that as we build our electronic filing platform. We are doing that. It's an interesting suggestion to consider for other parts of what we do. Got one up there. Over there, coming.
Thank you. My name is Royce Murray. I'm with the National Immigrant Justice Center. I wanted to raise for you the concerns about delays in the affirmative asylum program. I know that the asylum program has taken on a lot of responsibilities, an increasing number in terms of certainly credible fear interviews happening in greater numbers for families at the border, as well as the affirmative asylum interviews, and now with the increase in refugee processing, with the possibility of asylum officers being detailed over to those programs as well. I understand that there's going to be and has been an increase in hiring of asylum officers, but given that at present, I understand in Chicago, where NIJC is based, delays are 2 years for affirmative asylum interviews. In LA, I understand they're 4 years. With the hiring that you're expecting, are you anticipating bringing affirmative asylum interviews down to some particular goal? Do you think that the hiring that's happening will address and bring back to some sort of normal status quo for the timing of affirmative asylum?
I would say it's. I think the intent to attack the backlog is there. The hiring is part of what we're going to be doing to address that. I mean, I think you've correctly observed, and I think I've been transparent, that there are a lot of things pulling at those resources, which means that the other thing that we need to be doing and are doing is looking at different kinds of efficiencies to also make the process work a lot better. So I wouldn't necessarily talk about a particular target or a particular timeline, but all of these issues are being actively worked at the same time, noting we have certain targets what we need to meet in the credible fear world. We have numerical targets on the asylum world, and meanwhile we're fighting what is acknowledged to be a quite significant backlog in the affirmative asylum world.
Well, if I just may add a recommendation, as
Please.
you're talking with your other agency colleagues within DHS, if in terms of efficiencies especially, since I know that such a high percentage of those families are passing their credible fear rates, 85, 90%, there is an opportunity to not place those families in expedited removal and instead place them in 240 proceedings so that this isn't this additional burden and waste of resources. Thank you.
That is a suggestion that is noted.
Thank you.
Sir, how are you?
Good. How are you?
Good. Here, I'll let you have mine.
Thanks very much. First of all, I want to specifically thank Maria Odom because she does have a way of bringing agencies together to solve a problem, and she does it quickly, actually. We took part in a teleconference on consular returns. Consular returns has been an issue since I had a lot more hair, and it's been endemic, going on, and it's growing, and it usually costs a family. Wife shows up at an interview at an IV unit in a country, and she thinks she's going home with her husband, and she's not. And it's not necessarily going to be a month, 2 months, 3 months. I had a case this week that was 3 years. So Maria brought together all of the parties, and we heard great progress. And just the fact that she was able to bring the parties together, CIS is actually doing great things now, and the NVC is doing great things, and the U.S. embassies will come along too. But I thank you for bringing it, because I actually see light at the end of the tunnel. So thanks. I also wanted to thank you, because what you've done for citizenship is just great. I practice in Englewood, New Jersey, so we have Phyllis Coven and we have John Thompson, and the citizenship units are great. This is a transition year. It's an election year, so there's usually a spike up. But we've never been able to hit the 9 million people that you talked about. So question number one for the bigger picture was, the electronic platform you talked about is great. Do you have any idea of when? And the second and third is, This is the time that we really need to grab hold of the attention of people. So what you did with the ambassadors is great. Have you thought of doing other groups for ambassadors? And the other thing is, my parents ran to become citizens. They ran from from Germany, and the first minute that they could become citizens, they ran. It's different now. So you have to sort of, as you said, there are reasons why people become citizens and why not. So maybe, you were talking about enhancing ceremonies. Other ideas that you have, I mean, because now's the time. And thanks.
So I think thank you for pointing to the ambassador program, because I actually think that goes a long way. I actually was in your neighborhood about 3 weeks ago now, and we had a naturalization ceremony at the Javits Center in partnership, or actually hosted by People in Espanol, that was doing a big Latino expo. As part of the naturalization ceremony, we did something that has been going back to the time when Emilio Gonzalez was director, but which I'd like us to see a whole lot more of, which was we gave 2 American by choice recognitions. And the ones we gave that day were to Talia. Those of you who watch telenovelas, which is a great guilty pleasure, will know who that is. And Mariano Rivera, formerly of the New York Yankees, who many of you will know. And Mariano, I have to say, actually hit it out of the park. How he spoke of citizenship was incredibly inspiring. I believe he might have spoken mostly in English, but spoke a little bit in Spanish. But the beauty of this event, and I think we need to be doing more of this, was that because we were in the middle of this big expo, it was a mess. It was noisy. It was not your typical courtroom naturalization ceremony. But there were 1,000 people who were watching what we were doing. And as I started working the crowd, people wanted to take selfies, wanted to take pictures. I said, well, and I probably shouldn't have done this. I said, well, what's your, are you an LPR? And I probably shouldn't ask questions where the answer is maybe not one I'm supposed to know, right? But in fact, many of them were. And I think, to see, 100 people who had just naturalized, to see Mariano Rivera, who could not be a sort of more humble, more decent human being, talk about his life experience, I think had a tremendous impact on the folks who were there today. So I think we do need to do more like the Ambassadors Program. I think every time we talk to a celebrity, particularly an immigrant celebrity, about working with us on this, they're like, just tell me where to be and what to do. Jose Andres, who many of you know locally, is an excellent example. He has been very proactive and very willing. So we are gonna be looking for those opportunities, and a lot of them are also willing to spend some cash to promote citizenship as well. Thank you for that question. Sir.
Thanks. Good morning. My name's Ken Reed. I'm with the University of Massachusetts Amherst, and from the academic side of the house, if you will, Ms. Odom alluded to it earlier, but the change of status sort of meltdown this past cycle has been obviously a very devastating sort of event for the academic community, and it's really had repercussions not only for the individual students themselves, but you find it trickles all the way up through admitting departments and faculty. And if somebody's not going to be able to be here, I'm not going to admit an international student to be an assistant, teaching assistant or research assistant or whatever. I know there are a lot of systemic issues, and USCIS has been working on that, but I just thought it would be worthwhile to mention that, again, like so many other things, that this doesn't just directly impact the individual. It has such a knock-on effect. And so I'm just wondering if there are some tacit ideas that you have to improve the I-539 line and that product in particular.
One part of this is I always just have to hear the bad news. I think it's important to bring these things to light. We're looking at improvements on every front we can find. I think a lot of these issues are issues eventually that are going to require, as I said, the political system to take responsibility and to make some changes. Meanwhile, we're trying to make more efficiency. So thank you for that feedback and bringing those issues to light. I mean, I know. Yeah. Yeah.
Thank you for this wonderful opportunity. I know, a lot of things have to do with the law, with changes in the law, but like, for example, with improving now with the provisional waiver for more families to be able, do you think maybe at one point you'll think about provisional waivers for people that have been working for a long time too for one company? We have people asking us sometimes, I've been working for my employer for 10, 15 years, and he would like to help me. But, but there is no waiver for that specific. And it's based on skill, it's based on work. They've been working, they've been paying taxes. So I think there is the Congress to do this, or there is something that could be done administratively.
Yeah. I will assume that the scenario you're talking about is basically somebody who is undocumented, who's been working for somebody for a long time, and presumably doing a very good job, paying taxes, being very productive, and can we consider a provisional waiver for that person? I don't know that there is a specific category for that individual in the law that I'm aware of. I think it's part of where we were going in terms of what we were trying to do with deferred action. What I will emphasize about deferred action is that helps us help people right now. And so we've done that with a lot of the DACA kids. We've been able to help them right now. We're still going to need to work for immigration reform because the ability to really give that individual you just described a real permanent solution is really going to require the political system to step up. You. I got one, and Angela, I know you.
If I may interrupt, if we can
yeah.
Take two more questions,
Two more
then
questions.
your folks say
Okay.
you have to go.
Oh, okay. Okay. Actually, if you have time, I can do maybe about like 5 more. If it doesn't mess up your 6 more, because I see about 3 hands up.
Sounds great.
Okay.
Thank you, Leon.
What's that? What's that? Okay. 5 questions.
You can do it.
Okay. I saw somebody up there. I don't know if there's a mic up there for them. If not, I'll. Oh, there you go. There, and then I'll get you, and then I'll get Angelo.
Good morning. My name is Johanna Kelly, and we are coming from North Carolina. We work in a nonprofit that promote and protect immigrant rights. My question and my comment is related to your comment that USCIS is focusing in immigration fraud and notary fraud. So this is one of the biggest issues that we are facing in North Carolina. My comment is related to immigration fraud involves other crimes like forgery, perjury, obstruction of justice sometimes, and witness tampering. One of the biggest challenges that we have at the organization is when we are representing a victim of immigration fraud in U visas based on the qualifying criminal activity of perjury or obstruction of justice. We see that it's very difficult to plead these cases, to fight for these cases, because we feel like the burden is very high, and USCIS is always challenging the harm or even the qualifying criminal activity. So my comment and my question for you is how USCIS can coordinate or develop a better policy to kind of keep working on immigration fraud and at the same time help these victims, because this is a kind of crime that not just impact the individual, the person, but it's also against the system.
Yeah, no, I think the main thing is for us to keep hearing the feedback. I mean, I think you see that we're always introducing new policy changes. I know, for example, we're doing some thinking in terms of other ways that we can help victims of different offenses. Not just criminal conduct, but people who've been victims of labor abuse. So hearing this feedback from the community that's helping these individuals is important for us to continue to look at options of how we can do things differently. All right, I guess I will take actually 2 more. Angelo, you're going to get the last word. I'm going to take that one up there.
Okay, thank you. Thanks for being here. I have a question regarding processing time. So before I begin, though, I just wanted to commend you for all your actions in terms of expanding immigration benefits. We've seen a lot of positive outcomes this year with the H-4 EAD, the visa bulletin allowing for filings for individuals. So I'm just interested if you could speak a little bit to processing and how USCIS will be tackling additional filings in terms of speeding up processing timeframes, and more importantly, transparency in terms of the reporting that USCIS is providing to the public about their processing time. So currently on USCIS websites, we're seeing reports from August 31st. So we just want to help. I speak from the private practice as an immigration attorney, just how we can better relay to our clients what they can expect to see out of USCIS, so we can work together.
So two things. One, we're always hiring. We still have plenty of actually headroom. Big development is the Potomac Service Center, actually right across the river here. I think we already have about 100 people hired in there, but a lot more to come. And so that, as we add more people, that should have a positive effect. The issue that you just presented is not an issue with a short-term solution. It is hopefully an issue with a long-term solution, which is the way that we present cycle times is basically based on the sort of confirmed end-of-month data of a month earlier. Our technology and our business systems right now don't enable us to do better than that. As we fully automate, it is part of the intention of our automation that, in fact, we be able to deliver more real-time predictability to people as to what our cycle times are. Okay, Angela, and then we're done.
We've heard a lot today about processing delays, and I'd like to suggest that and ask why this would not be feasible. The changes in the visa bulletin are really changes to allow a filing and a receipting process initially to happen for people who are not going to get adjusted in a long, long time. And I really don't understand why you can't accept those filings at an earlier stage, put the money you get in an interest-bearing account for the things you don't have to do right now, and let people go on with their lives. They can get work permits and travel permits and be free of their employer's yoke after adjustment portability kicks in 6 months. I mean, it seems to me that it would be advancing the president's agenda to allow for portability and allow people to move on and be productive.
I like the idea. I will observe that I'm fairly certain that you've been in the immigration system longer than I have. If you go to one of our service centers, which I assume you've been there, and you have seen the acres of paper files in all kinds of queues and buckets and bins, I would be nervous about doing what you're suggesting until we are automated in a way where we really could manage the kind of queue that you're describing. I don't think it's inherently a bad idea, but I think we need to have the kind of business systems to really support what that potentially could mean for the agency. So I think it's one we should keep talking about as we hopefully move toward a more efficient system in the future.
You had to have been prepared if the Senate bill passed. You would have had a huge number of people having to file. So those plans should have been in place.
Those plans were certainly being built as that was going on. You don't actually get the money and the bodies to do that until you actually have an actual plan, which meant, for example, when we were sort of planning for DAPA-DOC expansion, it was going to be on our existing business platform. It wasn't going to be, some sort of dramatically new, super automated plan that we were going to have for the future, and also knowing that we were going to be doing it in an abbreviated time frame. So I think in the future we could get to something like that. My view is I think I would be nervous about doing something like that right now.
Thank you.
Okay, I guess I am being kicked off the stage, folks. It's always good to see you guys. I know.
Thank you.
I'm going to call attention. Shin Inoue, who is my press secretary, has one of the toughest jobs in the world, because I love people, and I hate saying no to people, which is a terrible quality, I guess, in a director of immigration services. And so he's always having the really difficult job of dragging me off stage. So thank you, Shin.
Thank you, Leon. Thank you very much. Thanks. You've been very generous with your time. It's always good to have you. I have a few announcements, so don't go. Let's see. Is that on? Can you hear me? Great. Thank you again to Director Rodriguez, and thank you all for your good questions. I thought there was a very rich conversation, and I look forward to more today. I want to also thank you for the compliment on consular returns. I want to mention, because I don't take all the credit, Fred Tronconi, Senior Advisor at the Ombudsman's Office, as well as Alyssa McGowan, our Chief of Policy, were the leads, getting us ready for that teleconference, and they pulled the good miracle of having all the folks at the table, and we'll continue to track the issues regarding consular returns. I also want to recognize Allison Posner, who is our Chief of Policy, and of course, you've heard from Stacy Shore, who is our Acting Deputy Director. This concludes our open press section of this program, so thanks to the members of the media who are in the audience. We appreciate that you took the time to come this morning. This will be our time for us to say goodbye. And we take this opportunity as well to take a break before our next panel. Let's take a 15-minute break. We have a little bit of wiggle room here. So let's convene back here by 11:05. Great, thank you.
We're going to start in about 5 minutes just to make sure everybody can get back to their seat in time.
Got it. All right, folks, let's start grabbing a seat.
I don't see him, but I'm looking for him. It's trying to wait. He's going to be on the microphone.
Welcome back. Give Mariela Melero a chance to sit down. All right. Welcome back. Welcome to our plenary. I am here with two friends and very honored to share the stage with them. I first have to say that Jennifer Higgins, you heard Director Rodriguez talk about her leadership in implementing and working to implement executive actions. She is a senior advisor to the director. She was very much looking forward to joining this panel. A highly esteemed colleague, a hardworking individual who I think has impressed us all with her skill and her collegiality. She's not here today due to a family emergency, so we wish her family well. If you can let her know that we appreciate her efforts in preparing for this panel, and we hope that we will have her back with us in the future, maybe for a teleconference with updates on executive action. I am joined today by Esther Olavarria, who currently serves as senior counselor to DHS Secretary Jay Johnson. You heard him talk about Esther in quite a moving way. I think those of you who know Esther have encountered her as an advocate, as a thoughtful mentor, as a great colleague, as a fighter for comprehensive immigration reform, and I am very fortunate to work with Esther and to learn from Esther every day. I am also here with David Shahulian. You may know David from his prior life on the Hill. He walks fast and he talks fast. He gets a lot done. He currently serves as Deputy General Counsel for our Office of the General Counsel at the Department. Both of these folks have been at the helm of our massive and impressive efforts to plan and implement the President's directive on executive action for immigration reform. I have seen the tremendous effort in the department. I have been impressed by your leadership, and I am so glad that you're here today because I think a lot of folks have questions about where we are, where we're going, and what we think will get done, over the next, how many months do we have left? 13?
440 something days.
That's right. So there is a lot of work to be done, and hopefully you walk away with a better understanding of how the department is prioritizing the actions that remain to be implemented. But maybe we have a chance this morning to look back and to talk about some of the lessons that we've learned about how we work inside DHS, but also how we work with our federal partners to do something so transformative and so important for the immigration community and for our country. So maybe we'll just jump right in and ask a few questions, and I promise you I will leave time for your questions as well. Maybe I'll start with you, Esther. So putting DAPA and expanded DACA aside, which we know are the subject of litigation, what do you think is the most important and lasting of the executive actions?
Well, I think, again, putting DAPA and DACA aside and expanded DACA aside, that we were very, very disappointed when the injunction came down. We were gearing up, as you well know, to start implementing expanded DACA, and lots of work was underway for DAPA. I think that probably the most important other administrative action that the Secretary announced on November 20th were the changes in the enforcement priorities. I think that they are significant. They provide the clarity that we heard from frontline officers in ICE and CBP leadership that they wanted. They wanted to know what are the rules of the game. In preparing and in drafting that memorandum, Secretary Johnson looked at the array of memos that had existed in the enforcement realm and came away pretty puzzled and wondered, how do officers in the field know what the rules are when you have memos that some of which are contradictory within themselves and others contradict each other. So he wanted to come up with something that provided clear guidance. At the same time, he had heard loud and clear about the concerns raised in the, by many of you in the room, congressional offices, many others, about individuals who have been living here for years that have committed no crimes, or who were arrested for very minor violations, and had significant equities. And those weren't the individuals that the department wanted to focus their resources on. He wanted us to focus resources on what he described, convicted criminals, the worst of the worst, national security threats, and recent border entrants. When you look at the priorities that he did issue that day, and you look at them closely, and you look at, for example, the report that MPI issued a few months ago, you'll see that something like 87% of the current undocumented population of the 11 million right now are no longer priorities. Unless they are convicted of crimes in the future, they are no longer priorities. It's unfortunate then that they couldn't go to the next step, and those who were eligible for DAPA then apply for DAPA. But it does give some level of peace of mind. So I think that is definitely significant, and it's going to be reflected in our end-of-year removal numbers too, where the numbers of people who we had seen removed in past years are no longer being removed. It's not to say that we don't have work to do. We have lots of work to do still as a department with respect to the exercise of prosecutorial discretion, the unless clause cases, as many in the room call them. So we have our work cut out for us there. But I think that change is fundamental.
Thank you. That covered my next question, whether, are you satisfied with the progress that our enforcement components have made in implementing the enforcement priorities?
I think that there has been significant progress. I used to get a lot of cases on almost a daily basis of individuals who many believe should not be removed. The number of cases that I'm getting has significantly decreased. In quiet conversations that I have had with advocates, some of you in the room, you admit to me too that the number of cases that you are hearing about also has significantly reduced, and our focus, I think, has in fact turned to the worst of the worst. But that said, yes, as I said, that there is still a lot of work to be done.
There is. Thank you. David, so you have been at the helm of our litigation response, right? And thank you. I know you have spent a lot of time and energy standing for the executive actions that this administration has put forward and that we believe we have the authority to implement. But the rest of the actions have involved guidance. Some have involved regs. Some have involved, other new initiatives, including the New Americans Partnership. Or the Partnership for New Americans. At this point, are we prioritizing what we're going to get done over the next 12 months? Are you concerned that there are things that may not get done?
So yes, we are prioritizing. No, I am not concerned that there are things that will not get done. I think some of our, with regards to employment-based immigration, for example, flexibility for workers, full implementation of AC 21, and other provisions in the INA. I think some of our best work is yet to come. We are working on 2 different regulations right now. We are working on additional policy memos and guidance that we expect to publish imminently. And let me just say, within at least one of those, hopefully within a month. And I think that they will be, I think they're very smart, and I think they will be very well received. And we are very excited about the work that we're doing now. But no, I am not concerned that we're going to leave things that we expected to do undone.
I think that there has been tremendous opportunity for folks to weigh in and the public to weigh in on some of these initiatives and comment on guidance and regs. I think there was a comment earlier today about the public receiving feedback on why certain pieces of comments and other stakeholder input has not been folded into either regulation or guidance. So I just want to flag that for you since you were in part of the conversation this morning.
I would just add that everything we'll be doing, of course, will be put out for public comment, notice and comment. So the regulations will have 60 days of public comment. Will be, so people will be able to comment. And the same with the policy guidance and some of the policy memos we'll be putting out. We'll also be putting those out for public comment.
Right. And that's such an important part of the process. I know there are many of you in the audience who are deeply involved in providing comments to us. So please don't stop. They are important. Keep telling us what you think will work best. And speaking of guidance, Esther, can we talk about the extreme hardship guidance?
Sure.
I think that in our annual report this year, we commented on the promise of establishing a presumption of hardship. We read the Secretary's directive as clearly asking USCIS to do its very best to implement a presumption of hardship, extreme hardship for adjudication of waivers. Some would say, and I think I agree, that maybe we're falling a little short of a presumption. Can you walk us through how the guidance came about and any aspects that you want to highlight that maybe build onto that concept of a presumption?
Sure, happy to do so. Before I do that, I want to go back to your last question, because I was in the room when I think it was Angelo who asked the question, I don't remember, with respect to feedback and conversation about why we didn't adopt the things that we adopted once we issue final guidance. And I would say that there's a lot of work that goes into going through. For example, in the extreme hardship guidance, we've gotten over 600 comments. I do not envy the group of individuals that have to weigh through 600 comments, and many are very thoughtful and provide lots of very good suggestions. Others not so much, but you still have to weigh through them all. And there is some measure of, as we prepare then the final rule, there is some attempt to address why we didn't do some of the things we do, but it's something that takes a lot of time and a lot of work. And the same group of individuals that are working on issuing that final rule then have to turn around and proceed to one of the other executive actions that we want to do, and we are confident we will do by the end of this administration. So that takes a lot of time. And maybe one way to do this is instead of, and I'll have to take it back to my colleagues at USCIS, but instead of having some kind of written document, we could do some kind of roundtable discussion. I mean, there's a limit to what we can go into and why decisions were made, but maybe some of that we are able to address through some kind of roundtable discussion. Mm-hmm. With respect to extreme hardship, a lot of work went into writing that guidance, both at USCIS and at DHS. We had a lot of internal conversations, and we actually went out to stakeholders and asked for their feedback, their ideas on how to draft this rule, and specifically the issue of the presumption of hardship. Right. We looked at NACARA, and the criteria in NACARA was with respect to a very specific population. The individuals that will be eligible to apply for the I-601 waiver and other waivers and have to demonstrate extreme hardship are going to be very broad, different groups. So it wasn't easy to follow the NACARA model, and we struggled with that and thought that if we put out certain factors, we would have an unintended consequence of creating a negative presumption for those who did not were not able to establish those factors, and instead came out with, and I can never remember the phrase that we used, significant consideration should be given to individuals who fall within these other sets of factors. And though we thought that was a better approach that wouldn't create the negative presumption. We don't claim to have exhausted the universe of factors that should be given significant consideration, and we actually welcome ideas from all of you here and others on what other factors we could look at. And if anyone has ideas on how to create a presumption of hardship that doesn't lead to negative inference, we welcome that idea as well.
Thank you. I think the guidance is just a tremendous positive step in the right direction. And as with all guidance, and I know so many of the deliverables in executive action have been guidance, are going to, the success of that guidance will depend on implementation and training at USCIS of adjudicators who will eventually apply the guidance to their adjudications. So I think it is important for us to stay focused and to continue to work with USCIS on not just developing the guidance, but also the plan on how that's going to be implemented and what officers will be receiving. And one thing that I know we continue to reiterate to the agency is using case examples in their trainings, positive case examples where they can see the application of those significant factors to an actual case scenario. And our review of USCIS training, I think there's still room to improve the way training is delivered.
One of the things that we tried to do was come up with varied examples, and again, welcome other ideas on examples that we could provide.
We'll open the mics up in a minute.
Adjudicators.
That'd be great. Thank you. So David, a lot of cross-agency collaboration for everything, really, yes. for a lot of the tasks that we've been charged with delivering, but also particularly including the call from the President in the memorandum modernizing and streamlining the U.S. immigrant visa system in the 21st century. Yes. Can you talk to us, and share with folks how you just give us some thoughts on the way the interagency has worked?
Sure.
On the wide range of topics and projects that we've been working on.
Sure. I mean, so yeah, almost everything we do involves the State Department, involves the Department of Justice and the Department of Labor, particularly on the employment-based side with the Department of Labor. So there is a lot of collaboration. We have weekly calls at the staff level when we're working on a particular issue. So for example, with regards to people who are in the green card pipeline on the employment side, we are working very closely with the Department of Labor so that they're, as Dave indicated as well in their regulatory docket, that they're also going to regulate in this space as well. And so our two rules definitely have to mesh. And so we are working very closely with them so that what we do, complement each other, the two rules. But, with the, everything we do, as even from the very get-go, when we were drafting the memos, we were working from the day I started. I actually started the day that the President gave his speech in the Rose Garden, indicating that he was going to implement these actions. And from that day, it's been I thought it used to be really busy on the Hill. I had no idea. It's been a sprint marathon, right? I mean, there's no question. We haven't stopped running. And, we bit off a lot. And, a lot is yet to come. But we have been working, with the Department of Justice from the beginning, thinking about what we could do, how we could read the statute, what was legally permissible, what wasn't, where we would draw lines. We took in at that time months of ideas. We put any idea that we had on the table. We considered things. We then ruled things out, for legal reasons, policy reasons, what have you. And we started narrowing the things that we thought we could do and we could manage and we could defend. So there's been a lot of that with the Department of Justice, but also again with everything we do, will impact state, will impact the Border Patrol, ICE, and so everything we do, we work in a collaborative fashion because we want, first of all, we need people to implement it, but we also need buy-in. We want people to understand it, to think that it's the right policy. And so everything we do, we try to we embrace the people that need to implement that and bring them to the table, hear their thoughts out and work it out.
That's right, and that's been thank you, David. Sure. It's been my impression as well, even our work inside DHS has been impressive. The level of collaboration, having been now in the department for 3 years, I can say that the opportunities to weigh in on all of the products that have been developed, the opportunity to work with our colleagues across the aisle, whether they're ICE or CBP or USCIS, and even our headquarter components in either office, I think has been exceptional. There has been a lot of transparency and a lot of good communication in the department. I like to think that putting executive action aside, that hopefully we're leaving a better way of doing things in the department. And I want to thank you both for leading the charge. And I know for the secretary, it's been important to have everyone at the table. For the deputy secretary, it's been incredibly important to have different voices and ideas and suggestions. And I said, people who can put forward new thoughts, concerns, but also to have the operators at the table. And kudos to our career colleagues, because they have been a very instrumental part of delivering. And I think, David, what they're all dying to ask you is what happened with the visa bulletin.
Right. Yeah, so let me first apologize for that. Let me just say that I think we know that pain was caused, and that people took what we first put out and took action based upon that, and there was a lot of concern. There continues to be a lot of regret at the department, and I assume throughout the federal government for what happened. But it was to boil it down, right? We were looking. There are statutory limits. I think a lot of people would like us to create a lot of people to file their adjustment of status applications earlier. There are provisions in the law that say we can only do it when you have a visa immediately available to you. What we decided was we could allow people, we could determine that the full panoply of visas available on the employment-based side or the family-based side were available at the beginning of the fiscal year, all 440,000 or 226,000 on the family side. And we could determine, based on who State Department believed would be able to be authorized a visa in that fiscal year, visas be available to them at the beginning so they could file their applications, and that would both allow people to file earlier, but also allow us to adjudicate applications, put people in the United States more in parity with people who are outside the United States, and allow us to adjudicate more. It would more consistently. We would create a little bit more stability in the program. There would be a lot less of pushing dates forward and then retrogressing, and people would have more certainty. So we thought there were a lot of benefits to that. So we asked the State Department to publish its qualifying dates, which were dates they believe people would be authorized for a visa and we could get it within a 8 to 10 month period with the idea, or 8 to 12 month period with the idea that at the beginning of the fiscal year that would indicate who reasonably would get a visa that fiscal year. And this is all out, by the way. There's a Charlie Oppenheim from the State Department filed a declaration in a lawsuit which explains all this. So I don't think I'm saying anything brand new here, but the dates, the qualifying dates that they published were qualifying dates that were not necessarily their current, estimates, right? They were they don't retrogress their qualifying dates when they retrogress the cutoff dates. Unfortunately, when they published their dates, they were not their current estimates as who would get a visa that fiscal year, we thought that was problematic based on our reasoning, so we asked them to republish.
Right. And they don't have to retrogress, right? Because those folks are abroad, and they can continue to prepare their cases after the fiscal year ends if they didn't get a number, right? For the folks who are abroad trying to use their qualifying dates to get their cases going, right?
Yes, that's why they don't retrogress them, because State Department's like, once they set a qualifying date, they already sent out the visa packets to them. Packet 3s is, those who practice in that area know. So there's no purpose for them to retrogress their numbers, their qualifying dates numbers, because those packets are already out.
That's right.
And so they just, but it's different for our ability to rely on that for our purposes here for adjusting status.
That's right. Thank you. Thank you. So going back a little bit, Esther, policy coordination. You're working with state, you're working with DOJ, you're working with labor, you're working with everybody, right? Not even mentioning our folks internally. Some of the challenges or even best practices that you've seen in policy coordination in this massive effort.
Challenges. I would say you need to reach agreement first within the department on any policy that you put forth. That can be challenging because there are very different, very diverse points of views within the department. And when we take it outside the department, you go from agency to agency, again, you encounter very, very different points of view. And you can't just walk away and say, no, we're doing it our way. You have to take the time to understand their concerns and come back with other suggestions and try to find, a way that, everyone then agrees and we can go forward. So I think that's the biggest challenge. It takes more time than you can imagine, even for the simplest thing. It's one of the lessons I have learned coming from, for example, the Hill, where you got sign off from a member you were working for and you could issue a letter. At the department, it's very, very different. And it takes a lot of patience. So I think that's probably the biggest challenge.
David?
I was only going to say that, and for things to work well, it needs to be collaborative. You need to go through a process, right? Because you do need to understand all the ramifications, the operational, the policy ones as well. But you want people to own it, right? I mean, it doesn't. If we were to just come in and put out some edicts and say do this, if people don't understand it, don't buy into it, don't understand why, it ends up not working well. And so we've made our mistakes. There's no question about it. But I think we've had more successes than failures. I do think that there, as you were saying, it has been a very collaborative. I think we've been, across the agency through all the different immigration components, and CRCL and the Ombudsman's office. I think we've heard that. We've heard the appreciation for that.
Absolutely. It's important, and I promised you I'm going to open it up for questions in a second. But it is important, and I want the public to understand what happens behind the scenes in coordinating policy changes when you're considering not just different components, but different federal departments and agencies. They're different mission spaces and they're different equities. I think this is legacy work. I'd like to think that it is. And thank you all for your patience and for being the stewards of this process. So let's go ahead and turn to the floor for questions. I may have a few more, but why don't we open it up? We have one down here.
Someday I'll be, I am on. Good for me. I know somebody says that he never turns down an open mic. But in any event, thank you, as many people have said, for doing this conference. It's not only useful in terms of the information, but also in terms of seeing the bodies that are behind the information. And they're always very impressive. I guess I have two quick questions. One is, I'm a lawyer in Washington, Frederick Schwartz, and so I have one lawyer question and then one policy question. Who are you working, who is DHS working with in terms of the appeal and also the litigation below? Is it DOJ that's taking the lead, or is it the department that's taking the lead? And how is that working out?
Just to be clear, you're talking about the case in the Fifth Circuit, the Texas versus?
Yeah, I think you guys have heard of that, right?
Yeah, we just so you know, we have a lot of other lawsuits that we're dealing with, so that's
well, I've actually sued you a couple of times, but those cases are over.
I was including those. Sorry, your other question?
Well, I don't think I have an answer to that question.
Oh, no, I thought you wanted to ask.
And the other question is, you've mentioned the collaborative effort, which I've been in the government, and I understand that if you don't have everybody on board, you'll have a sinking ship very soon. But you didn't mention the White House. About a year ago, the president issued his views on what could be done within the statute, with input from the department. But who at the White House is dealing with this issue, and are they being sufficiently helpful? And anything you say will be held against you.
So, there are cases that the department leads on. So there are a lot of, smaller immigration cases where we take the lead in litigating throughout the country. But on these kinds of cases, the large cases, there's no question DOJ takes the lead. We work very closely with DOJ. Great team, both beginning in the the Civil Division, and then now it's Appellate, and the Solicitor General's Office has been involved from the get-go. There's been a team at DOJ with a team at DHS that has worked on every pleading together. There are strategy sessions. There are moots that we deal with. We of course try to get them all the facts when they need numbers or analyses. We provide that, but we work very closely together. But they are the litigators, and so they lead on that. Does that make sense? Does that answer your first question? Yes.
All right. And then with respect to the White House, we do work very, very closely with the White House. They play a critical role in the interagency clearance process that we mentioned. Let's say one of the regulations that David is working on. They will coordinate, the clearance process with Department of State, Department of Labor, Department of Justice, anyone who has equities in it. We talk to them on different policy issues. Chiefly, it's people within the Domestic Policy Council, but also the National Security Council staff as well, National Economic Council. It depends on the particular issue, but there are a number of individuals and agencies, sub-agencies within the White House that we work very closely with.
Thank you. There's another question down here.
Thank you. I'd like to ask about some of the details of the proposed rule on STEM EAD issues. One surprised me in a way that it indicated that ICE would be conducting site visits at E-Verify employers to make sure that the terms and conditions of the plan that is required to be presented in order for the EAD to be issued have been satisfied. But then when you go into the actual proposed rule, it says DHS will conduct site visits. And it didn't say ICE, and it didn't say FDNS, it said DHS. And so I'm concerned about the due process protections and procedural protections associated with those site visits. If they are unannounced site visits like FDNS has engaged in, and if they are in fact handled by ICE, ICE is the same group that issues notices of inspection under the I-9 program where they do give notice. And it just seemed like it'd make me queasy as to how this was all going to come out. And did you think through how that would work?
You're not going to be satisfied with my answer. Here's my answer. We are in the middle of a comment period on that rule. You're talking about the STEM OPT regulation, and we are ethically prohibited from discussing that rule publicly outside the notice and comment period without then making that same opportunity for comment available to everybody else. So we would have to, I'm sorry, I'm just going to have to refrain from answering that question. I'm happy to answer it after our comment period closes, or I am going to suggest that you submit a comment that we will respond to.
Okay.
Through that process.
The other question, I'm very much in favor of this proposed rule, but I think you left out a vowel in STEM. It should be STEAM for the arts. As a graduate of the liberal arts, and knowing that creativity is a job producer in this country, just look at, if you saw the movie Steve Jobs, that gentleman, a Syrian, a person who hailed from Syria, did quite a lot of job creation and was quite artistic as well. Why the omission? And I know you can't answer that, but
I was going to say, see answer one.
I'm personally offended at the exclusion of the arts. That's all I wanted to say.
Okay.
Thank you.
Thank you. It's a quiet crowd, quieter than I thought. Oh, there's a question over here.
Margaret.
Hi. My name is Margaret Stock. I'm in private practice as an attorney, and I'm a retired military officer. We have Veterans Day coming up next week, and I wanted to ask about some issues of concern relating to the Department of Homeland Security that have to relate to the military. Under Janet Napolitano's regime, the Basic Training Naturalization Program got started, And it's still in effect, I believe, for 4 of the services: Army, Air Force, Navy, Marine Corps, but not the Coast Guard. Coast Guard's part of DHS, so I guess that's an issue with implementing at DHS. But recently we've seen some significant problems with the processing of military naturalization cases. They're taking longer and longer. They're well outside the 6-month mark that was put in the record by Congress. That law has expired now that mandates 6-month processing of military cases, but they're taking a lot longer, and I'm getting complaints. Even while I was sitting here, I got a couple complaints from soldiers who turned in their applications a long time ago and nothing happened at basic training, and they're still at advanced individual training with no progress. I'm just wondering if the leadership at DHS is aware that basic training naturalization is kind of slowly crumbling after having been a success for a while. If you're aware of that, and if any measures are being taken to go back to the successful model we had in place a couple of years ago.
I can take that. Margaret, no, I don't think that these issues have been brought to, at least they have not been brought up to my attention. I have heard several comments from people in one particular field office, so I'll be interested to hear from you as to where you're seeing it. Do you see it widespread? And to learn more about what you're seeing. I have other concerns that I'm willing to discuss with you regarding some pushback that I have experienced from adjudicators who think that naturalization at basic is too soon, that it should be sometime later down the road. So I'll be also interested in seeing, in hearing what you heard, if any, along those lines, regarding adjudicators' disposition towards this program. So I'm happy to talk to you offline, or if you have any other information to share with us as far as prevalence and any particular areas in the country where you're seeing these issues pop up.
Right, and I can address that. I mean, I think that's interesting that the adjudicators are making a policy decision that they don't like a law. The law says that they can file their application for citizenship after 1 day of service. So there's no requirement they actually have to wait until graduating from basic training. That was a policy decision made by the Pentagon in conjunction with DHS, that it made sense to do it in conjunction with Family Day and graduation, and it'd be more meaningful. But for adjudicators to be saying that they just don't like it, and
and I'm wondering if you've seen a trend regarding that issue, or if you're just seeing just plain delays. And we're not part of USCIS, so when we conduct site visits, adjudicators may share some of their opinions about current law or current procedure. I don't see it as a growing trend. But that has been the only issue reported to our office. I'm just curious to see.
Right, I see it as a trend, and I can tell you what some of the causes of it are. The administration mandated the single scope background investigation for all the MAVNI recruits, and the SSBI process is broken down because it's done by OPM and contractors, and I think you know what the problems have been with OPM and its background investigation. It's been in the news that they're having significant issues with that. So the SSBI process is broken down, and apparently USCIS can't naturalize anybody if there's an open SSBI investigation going on. So that it's rock in a hard place, bureaucratic catch-22, where the agency doesn't seem to be able to complete the case because there's another agency that hasn't done its job, but the requirement to do the SSBI on all these people doesn't make sense anyway. So there's a mandate that got put in place that doesn't make sense. It's causing the rest of the system to cascade. And that's part of the problem. I'm happy to talk with you, but I literally got like 3 text messages today from people sitting at basic training whose cases got missed while I'm sitting here at the conference.
All right.
So
we're happy to help, and glad that you're bringing this to our attention. And I like your idea of approaching the Coast Guard to see if they're ready for such a program, and I look forward to speaking with you later about how maybe we can make that happen.
I was just kind of making a little bit of a joke. I was told by DHS that they haven't implemented it for the Coast Guard because there aren't that many non-citizens who join the Coast Guard. So it didn't make sense for them to have, a dedicated officer helping people because they just don't take too many non-citizens. But I don't think you need to work on that.
All right.
Okay.
All right. Thank you, Margaret. That's one less thing I have to work on then.
Except maybe for public relations.
All right. Thank you.
First, I wanted to thank USCIS for all that it's done post-DOMA to help same-sex binational couples reunite, and the extreme hardship waiver can definitely help that further. I was really happy to see sexual orientation explicitly listed. My push, and I'm submitting a comment about this as well, is in the examples to make sure that there's a same-sex couple in the examples. I think that'll go a long way towards, ensuring that a presumption of hardship is made without a negative inference. So I look forward to seeing the final guidance. Thank you.
Thank you.
Oh, no, that's good. Yeah. Thank you.
All right.
By the way.
Let's see. We have time for one more question, one or two more questions. So this is your chance.
We have a round two over here.
All right. We'll let Angelo ask a second question.
Thank you. I am puzzled by your answer, David, on the changes to the visa bulletin.
Sure. Oh boy.
What I'm not quite following is how the retrenchment that occurred in the dates is in keeping with the president's policy on trying to allow people to have job portability and trying to allow people to have work permission as they wait patiently, since the whole concept was to preserve these people so they could become registered in the pipeline for permanent residence and the employment-based side of the visa bulletin. And I asked Director Rodriguez earlier why you don't just take the fees in, allow people to get EADs and advanced parole. They know they're not going to get their green card any sooner, but at least the benefit extends to the spouse and working age children. The travel benefit is a very meaningful benefit. And he said, I'd be reluctant to do that because there's probably not enough room at the service centers for the files. Well, you know, you would have had to use the room at the service center for the DAPA and expanded DACA cases anyway, so that doesn't really convince me. And he said also that we don't have the technology to do it, and neither does that convince me. And so I'm trying to understand how what you did was in keeping with the president's stated goals.
I'll answer that very directly. We did not, so the change that we made was not done because we wanted it, because we thought it was the right thing to do. I would love to allow every person who has been sponsored for permanent residency to file their application for adjustment of status and have greater flexibility and portability. We'd love to do that. That's what we're trying to improve that. I think what we're going to do now is going to help as well with regulation. The reality is that there are statutory limits to what we can do. And we can want something all we want, but when the statute says you only can file an application for adjustment of status when a visa is immediately available to you, to the applicant, that is a limit that we have to take into consideration when we put out a policy. So if we allow every you may disagree, but if we allow every applicant knowing that they're not going to get, a visa is not going to be available to them for 7, 8, 10, 20, 30 years, I don't know how we justify that under the statute. So what I would say is that we need to change the statute. Absolutely, sure. I mean, we can get into a legal debate, that's fine.
I would. It would be very easy to just say, we interpret the statute to mean that filing the application is the actual act of presenting it for adjudication, and it's not the date that you register the submission of a form into the system. It would, that applies in many, many different circumstances. If you file a labor certification, you have to be eligible continuously to qualify up to the date of the adjustment of status. So why couldn't you just deem it to be the case that we interpret the phrase filing to mean the date that the adjudication occurs, whether by interview or by waiver of interview?
You'd have to interpret the word file in two different places, two different ways. You'd have to say that for purposes of filing an application for adjustment of status, you consider it filed not when it's submitted, but when it's prepared for adjudication. But yet, when it comes to 204J portability, you would interpret filed, because they're to use the same word, to mean the day it's submitted. So you're taking the same language and you're interpreting it two different. And that presented some problems to us. Okay. The reality is that this is particularly in the employment-based area. It's heavily regulated, a lot of statutory text, and you have to navigate. It's not just. There isn't a ton of discretion there, right? There are a lot of, and it used to, that is statutory text that used to say that you could approve an application for adjustment of status if there was a visa immediately available at the time of adjudication. And that was specifically changed by Congress to say at the time of filing. And so I think we had to take that into consideration as well.
If I could add,
Yeah.
We spent a lot of time looking at the things that we thought, and the Secretary especially thought, that were legally permissible under the law, and looked at this, looked at quite a number of other issues.
I hope you looked at Cyrus Mehta and Gary Endelman's articles on how to do it. They offered a roadmap.
We did.
We did.
And they presented it again in the litigation.
Yeah,
So
we did.
And the Thanksgiving turkey theory.
Yeah. And in the end, the Secretary made decisions with respect to things that he thought were legal, since he was going to be the one that would be out there defending the policies before Congress and the public. And he thought long and hard about a lot of these issues. And unfortunately, in some cases, we just need changes in the law.
This has been, I hope you found it helpful to hear from these folks and to understand how we've done the important work of implementing the President's executive action directives. Any final thoughts before we go? Are we better off at a whole of government approach because of this incredible exercise?
I would just still say that on some of these issues, there are other things that are coming down the pipeline. So I would just say, to the best you can, reserve some room for judgment. Or reserve your judgment, right? But we're trying to do more in this space.
The other thing I would say is we don't have a monopoly on good ideas.
Yeah.
So if others in the room have some good ideas with respect to administrative changes that we can make within our legal authority, we welcome the ideas. Send them. We'll look at them. I'm happy to discuss them with you.
You've been incredibly generous to be with us this morning. Thank you. Thank you all. And
thank you.
Thank you. So we'll break for lunch. I would like to acknowledge before we go that we have the former ombudsman, the first ombudsman, the pioneer ombudsman, Mr. Prakash Khatri, with us. Thank you for joining us, Prakash. All right. So we'll see you after lunch. Thank you.
And before you leave, just a few items. One, we did arrange for a $10 box lunch at the cafe that you can pick up. There's vegetarian and there's meat varieties. It doesn't include a drink, but it does include a cookie. If you don't want to go to the cafe, there are some restaurants, I believe, listed in your materials or something that was sent to you ahead of time. Please remember that the afternoon sessions, there will be one session in here, but two of them will be upstairs in the Washington and Jefferson rooms, which can be reached by the elevator or the stairs. If you're not going to be joining us for the afternoon, if you wouldn't mind, please remembering to submit your feedback form. And don't forget that coming into the archives requires going through security, so we try to give you an extra long lunch, expecting you to be back on time, so please give yourself some time to get back through security. Enjoy your lunch, and we'll see you after. Thank you.
talk too. So you don't. What's weird about those mics that it's like positioning them. They like those two weird ones don't.
Check, 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 check. Check 1, 2, 3, 4. Excuse me, please. Thank you. Check, check. Check 1, 2, 3, 4. These are going out live on the stream. That's why I need to keep it short.
Check, check.
Check 1, 2, 3, 4. One, two, three, four. many chairs do you need, ma'am?
We're going to be very intimate.
I thought the moderator was, are you the moderator?
I'm the moderator, but it's 8 people total, and I'll stand at the podium, but that means that 7 have to sit down.
Oh, I was told there were 6, so I apologize for that.
No, that's quite all right. These things happen. We'll manage. They're definitely going to be sharing mics, they know that. I'm going to tempt them. Play around with this and figure out if it's on here. Oh, it is. I'll be darned.
I'll take care of those name plates and you can look through the presentation.
Okie dokie. I just want to get them all set.
Sure.
Just because I'm going to put the two CISOMB I'll grab this to the original.
Well, it works there.
Okay, well, it works here.
Thank you. Okay. All right, I'm going to go back to check on my speakers who are all
Do you
behind
want me
me.
to go wait for you?
No,
Oh,
no,
they're
no, they're
behind
back.
me.
They're all
Oh,
back.
okay.
The only one I'm missing is Chev, Sharvari Dalal-Dani, who is from OCC. I know her, but I got a pack full back there. Yeah, I think so. All right, she'll do that. Okay. Thank you. Just hold that side up really, really, really high. Sure. If you need to.
It starts at second and it starts at 5 minutes.
I have my watch for everything else.
Okay.
And Angela will make sure that we
Okay.
have lots of questions.
Okay.
Yeah. Thanks. Mm-hmm. It's not quite so much. So I'm putting this down. All right, let me go get them.
It does keep me on like there's too much of it. It's hard.
Which one do I need?
Just all the way to the beginning on the blue screen.
Oh, I can't do the blue screen. This is the first one? Yeah. Yeah, no, I think that's it.
Oh, there he is, okay.
Sorry, Fred. You're like,
It's all right. It's all good.
you're like at the end of the very end here. Hanging off the end. I know, I'm like, I can't see.
Good afternoon. Thank you. I just want to make sure you were all still awake after lunch. Thank you. My name is Alyssa McGowan. I'm the Chief of Policy for the Office of the Citizenship and Immigration Services Ombudsman. And I have the honor to oversee what is a huge panel of experts over here to discuss the so-called hot topics of recent note in employment-based immigration. As was discussed earlier today, maintaining global competitiveness and helping employers and workers has always been a key feature of the executive action implementation. But it only underscores the fact that employment-based immigration has always been a significant component of USCIS's services delivery. While every year brings new challenges to the business-based side of the agency, these past several months have been especially privy to the development of new policies, new guidance, new interpretations, new regulations, and new clarifications of long-established interpretations. My distinguished colleagues here today will cover some of the critical happenings, focusing not only on those substantive areas where possible, but only on their impact, both in the operational challenges for the agency and for the filing community that it services. I'm thrilled to have here today the people that I truly consider to be experts in the field. Let's see if I can do this, starting let's see. We'll start from one end to the other. We'll start right in the middle. Shivari Daldani. Chev is the special policy counsel in the Office of Chief Counsel for USCIS. Sasha Alexander Haskell is branch chief for the Service Center operations. Kevin Cummings is chief of the Business and Foreign Workers Division in the Office of Policy and Strategy at USCIS. Ciro Parascondola, did I get that right?
That's right.
Yeah. Is the Deputy Chief for Business and Foreign Workers Division in the Office of Policy and Strategy. Peter Chiron, who is the Assistant General Counsel at Deloitte in New York City. Marcine Seed, Principal of the Seed Law Firm in Palo Alto, California. And finally, Fred Tronconi, who is Senior Advisor for Employment at the Office of the Ombudsman. We got a couple of quick housekeeping rules. Number one, if you still have a cell phone that's on, number one, it's not going to work down here anyway, so turn it off, put it to vibrate, do whatever you want, but in case you haven't done that already, please do. There is no eating or drinking in this room. I'm still not sure how this does not qualify as eating or drinking, but they told me I could do it. And finally, please, you were given feedback forms. Please use them. We can only improve these conferences if we know what we're doing right and what we're doing wrong. And that's only you can tell us. We're going to cover a lot of issues in the next 87 or so minutes, but we've allowed plenty of time at the end for questions. If we all talk, as long as we all remember to talk fast. It's usually easier for you to write the questions down in those cute cards that we gave you earlier today when you picked up your packets. We gave you index cards. Please use them. They're wonderful. Please do not make the efforts of my colleagues have gone in vain when we sat there stuffing all those folders. So please take them out, use them. It's easier for you to write the question down while it's fresh in your mind, and we'll answer it at the end of the session. If you really have to, we do have microphones. And you will notice we don't have ushers today. It was only in the morning sessions. We don't have people that can bring the microphones to you, so you will have to actually get up and go to the microphone in order to be heard, particularly on the live streaming, which is continuing. The only other rule is please be respectful of our colleagues here. They've given up their time and are sharing their expertise. They are not going to be able to answer every question that's here today. And as I said before, this is a brain trust up here, so they don't handle every aspect of the agency, even though you might think that they do, and sometimes I do think that they do. So, for that, we probably need a stage the size of Madison Square Garden to get all the experts in the room. So please do understand if there's something that we cannot answer for one reason or another, and we'll try to make that clear. There is a lot that we are ready to touch on. So, picking up where this morning's panel left off in some ways, Maria talked about the White House report on modernizing and streamlining our legal immigration system for the 21st century. It was released in July of this year. And of course, it had significant focus on employment-based immigration issues. As you know, the president charged all the federal immigration agencies with modernizing and streamlining the system with 3 stated goals. Number 1, grow our economy. Number 2, help U.S. businesses and workers. And number 3, protect families. Well, 2 out of 3 would fall within our bailiwick. So it is no surprise that a good portion of that report was devoted to employment-based immigration. As you know, it was a public input initiative that was co-led by Department of State and Department of Homeland Security. It resulted in 1,650 comments. And as Angelo knows full well, that all those comments were read, they were all analyzed. While they weren't all answered, they were all organized, and you can still read them today. They're up on regs.gov, so you can return to them time and again. Kevin, can you tell us how USCIS played a role in the development of the report's recommendations?
Sure thing. Is this on? Can everyone hear me? Okay. We were responsible for collecting the comments at USCIS, summarizing them, and then recommending courses of action with regard to the suggestions. We then provided analysis and insight to the White House on their proposals and provided comments and edits, technical edits on the report draft itself. And of course, we're now responsible for various initiatives that came out of the report itself. So that's pretty much it.
So is it safe to say that USCIS was not the primary drafter of the report?
We were not. This was a White House generated document. They were the primary drafters of the visa modernization report.
Okay, going a little bit in more depth into the report, Fred, can you tell us a little about the report's emphasis on holistic case adjudication modernization?
Well, yes, thank you. The visa modernization report really talked about how the agencies, the various departments that are all involved in the immigration process need to be more integrated in terms of the communications and development of policy. And it's substantially one of the largest challenges, I think, that most immigration practitioners and stakeholders face as they are trying to deal with the 3 agencies, Department of Labor, USCIS, and Department of State in the various forms, especially in the employment sphere. Of course, ICE is part of that as well, so I don't want to drop them. But that's, largely, that was one of the large issues, or largest, I think, lifts that really still exists. And it's a challenge that I think, it's a challenge that requires money, requires putting the people in the room, locking them in a room, and trying to work out what they can do as quickly as they can, because the integration of communications could make such a difference.
I think that's absolutely right. Sasha, many of us were very excited about the announcement of the Known Employer Pilot Program. Can you tell us what it actually is and what the goals of establishing such a program is?
I'd be happy to talk about it at a high level. USCIS was given the lead in developing the Known Employer Pilot, and we are working with Department of State and CBP. And the focus of this pilot is primarily on H&L adjudications. And we expect to be kicking off the pilot with selected employers by enabling the capture of information from certain employers in a more holistic fashion to be able to make some of the basic eligibility requirement analysis available across analysis that we would make in individual petitions to explore making it in a more global fashion, making those eligibility determinations.
Where does the project stand right now in terms of, when might we expect to see something?
Well, we expect to be making some announcements by the end of this calendar year in terms of the structure of the pilot. Many of the business rules that are going to be instituted are still in the development phase, so it probably wouldn't be a good idea to be too specific on that. But a couple of things that have happened on the IT side, we've been working a lot on data storage issues. There's just a lot of moving parts to determine about how we're going to manage this data in a more holistic fashion.
Thank you. We were also given reason to believe that the long-standing AC-21 regulation would at last be promulgated. And David Shahulian this morning in the plenary with Maria not only hinted at that, but pretty much darn well said that we would expect to see something. Ciro, can you tell us where it is right now to give us some more hope?
What do you mean at last? I mean, it's only been 15 years at last.
I have children that age.
Well, it is a very urgent priority. In fact, in this rule, we're also incorporating other proposals that are part of the President's Executive and Action Initiatives and that were announced by the Secretary in his November 20th memo of last year. So it is the highest priority for us. It's a very urgent. It's what our team, Shev's team, what Sasha's team was working night and day on. So the AC-21 is incorporated into it, but we have a lot of, not a lot, but other stuff in there that really works towards getting some of these mandates accomplished.
Well, thank you. I know what it takes to put out a reg, and I can appreciate the difficulties in some of the things that Esther and David talked about this morning about the collaboration and getting buy-in at all levels.
Well, the beauty of it is that we have like the steam now to get this AC-21 rule pushed out because we have the executive action initiatives to go with it. So,
well,
thank you.
Thank you. Okay, visa bulletin. The topic everyone loves to talk about. We recognize that we're in litigation, that, that while David was comfortable making some comments this morning, that perhaps our colleagues from USCIS will not be so comfortable in discussing this. But I think we obviously have to acknowledge that, this was a big deal this year for the employment-based community. Fred, can you quickly summarize the issue and in particular what the current visa bulletin means for would-be applicants?
Yes, sure, thank you. So executive action was the president's way of trying to move the immigration issues forward in the absence of Congress's action. And visa modernization is one aspect of it. And the employment side, we're talking about, again, the employment group here. There's 140,000 visas that are available each year for immigrant employment visas that are available each year. The idea with the visa bulletin that was issued on September 9 was to allow for, as David Shulian said this morning, was to allow for earlier filings in anticipation of a visa being available and being available within a future that was predictable, that future being a year. And so, and as David Shulian, again, Deputy OGC, indicated, the thinking was that immigrants who file under the adjustment of status visa bulletin filing date would be able to move all the way through to what is now final action. So the visa bulletin has two different dates in it. It has a date you can file, and there's a date for final action. The filing date was established initially in with the September 9 date to be the same date that Department of State uses for what they call qualifying dates. Qualifying dates are the dates that Department of State uses to decide when they start calling to immigrants overseas, those who are not in the United States, to start preparing their documentation in order to be ready for when the priority date becomes current for them, that they could then go to the embassy and get their visa. So what happened was USCIS, DHS, USCIS used those qualifying dates And it was really that those dates were, they were right at one point in time, and then there was some retrogression, and that retrogression didn't occur on the priority dates, but did occur on the visa bulletin. So that was an error, and that error, it was discussed, as David indicated, in Charlie Oppenheim's affidavit, which you could probably find if you want to dig deep. Ultimately, a revision was made to that visa bulletin it was made on September 25th for the October visa bulletin, and that it corrected it to bring the filing dates into compliance with being able to process through within a year. So what looked like perhaps would have been a gift to many immigrants who were waiting for a long time and thought that they would be able to file in September, it was an error, and ultimately was corrected. And it does look like there will be 5,000 to 10,000 immigrants, employment-based immigrants, that will actually benefit from this revision under visa modernization. And so we're pretty happy to see that. It may not be what everybody wants, but it is progress. And USCIS has a web page that now they will, after the visa bulletin is issued, they will also a few days later determine whether those filing dates as published in the visa bulletin will hold. And so if you have any confusion, go to the USCIS website, and it will indicate whether you can file under the filing dates that are in the visa bulletin. And as of October and November, the answer is yes, you may file. So.
Speaking of that webpage, Sasha, has there been guidance issued with respect to these would-be applicants in terms of anything special that they need to do?
Our standard procedures for accepting adjustment applications remain in effect. One issue that I believe was raised in terms of the 693 medical form, and it's hard, I think, to catch up our forms for instructions at times because of the process. Changing a form or form of instruction is a long procedure, but if there's any questions about that, I would encourage people to go on the USCIS website. Under the adjustment pages, it's not noted in the 485 instructions, but in the 693 instructions, it is you have or an applicant has the option of filing their medical with their adjustment application or subsequent to the filing of their adjustment application. So in terms of, I think anxiety about getting things done in advance of filing an adjustment application, that's probably the biggest item. And we have developed some accommodations for that. And it's my understanding that in the next form revision for the 485, those instructions will be updated in a similar fashion. But to some, our standard case acceptance process remains in effect for filing employment-based adjustment applications.
Thank you for the information about the medical examination, because we did, when the visa bulletin was first released at the Ombudsman's office, we received a number of calls and questions about, do I have to file my medical examination? And it took us some looking to make sure that we were telling people the right thing. Peter, can you discuss a little bit about industry's perspective?
I can, and if I could just take it a half step back, I do want to thank the department, thank the Ombudsman's office, Maria, for inviting me here to speak and give a perspective from an industry and employer's perspective, and to do it on a distinguished panel like this with really the experts that are around me. And the United States Constitution is 2 floors above us. It's quite a humbling experience. Now, with that said, I'd be happy to provide the industry perspective on the visa bulletin. This was a hard one to swallow, and you all heard David's comments this morning. I'm not going to belabor the point and what happened and the finger pointing, but from an industry perspective, it's been a year that was wrought with, or started off with promises and optimism, and that started to go south quickly with particular policies which became a little more restrictive on how to do business, followed by AAO decisions that really required adjustments for companies, and then to have this hope to be able to communicate to employees that finally there's something that's going to improve your situation, your quality of life, your family's quality of life. You're not going to get a green card. Nobody's saying you're going to get a green card, but you're going to be allowed to file applications, which will give you more portability in employment opportunities. And from an employer's perspective, it would mean that a lot of our employees could actually leave. But that's good, that's robust, that engages in the innovativeness of the economy and the talent pool and doesn't let it go stale. So from a business perspective, it's really analogous to a company that's doing really, really well. Come November, you promise your employees a holiday bonus of thousands and thousands of dollars. Those employees relying on that promise go out, they buy cars, they buy holiday presents, they pay off loans, they give money to charity, only be told that they don't have that money anymore. So it was tough, but of course, we understand the dynamics, and we do remain optimistic that it is going to improve. I do believe in the modernization report. I do think that the people at USCIS, the good people at USCIS, are going to continue moving the needle in the right direction and work with the state because the intentions are in the right place. It's just finding the mechanisms, the operational component to strategically make that happen.
Speaking of components to strategically make things happen, the latest in L1Bs. As you know, we had a memo that was released on August 17th that had been many, many, many years in the making, I believe. Yeah, Kevin and I had a lot less gray hair, I think, when it all started. It really did sort of dramatically impact those companies who face intercompany transfers for those with specialized knowledge. Chev, can you kind of summarize briefly what the memo was intended to do and some of its major points?
Sure. I will try to be as brief as possible. It's kind of a lengthy memo, but, and yes, we recognize it was very long awaited, but hopefully it went into effect on August 31st, so we have it. And we went through a period where we reviewed everybody's comments very carefully and considered them. So hopefully between the memo that was published for comment and the final memo, you saw a difference that addressed a lot of concerns. And the concerns were wide-ranging, so they came from every angle. So just to highlight, the goal of the memo was to consolidate previously issued guidance. We've had many memos over the years. The goal was to consolidate those and ensure consistency in adjudications as a result. It clarifies the definition of specialized knowledge, sort of relying on the common dictionary definitions. And it also clarifies compliance with the L1A Visa Reform Act. Sort of 6 points that just to highlight that are key to the memo. The first is that specialized knowledge generally cannot be commonly held, lacking in complexity, or easily imparted. But on the same note, knowledge generally may be considered specialized if it would be difficult to impart to another individual without significant economic cost or inconvenience. Second, specialized knowledge does not need to be proprietary or unique to the petitioning organization. Third, a petitioner is not required to demonstrate the lack of readily available workers to perform the relevant duties in the U.S. Fourth, specialized knowledge does not need to be narrowly held within the petitioning organization. Fifth, specialized knowledge workers do not need to occupy managerial or similar positions or command higher compensation than their peers. And sixth, eligibility for another non-immigrant classification is not a bar to L1B. The memo discusses how to evaluate these claims and then discusses the L1A Visa Reform Act, so to provide examples of how that can be established. So that's sort of it in a sum.
Thank you, thank you. Marcine, okay, you've heard the goals. What do you think? What's been the effect?
People are laughing with the audience. So let me just say that we're very, I think practitioners out there are really, it was a breath of fresh air to see that the agency was so forward in saying that the burden of proof is basically the preponderance of the evidence. So I don't have to keep reminding them when I send in my submissions on L1B cases. And what was refreshing to see is that, at least the agency is going to give deference to prior L1B adjudications involving at least the same parties and with the same facts. So with that, I have to kind of turn the other way and say that although we see some really positive things in the L1B memo, and they've been long awaited, I really see this memo as what I told Alyssa as, well, I'm just going to say a new era in L1B adjudication. I think we had all hoped that the memo would really give a lot of guidance and really simplify things for practitioners, but how I've been hearing from my colleagues is that they believe this L1B memo is going to, in fact, make things a little bit more complicated, and it hasn't simplified things for both adjudicators and practitioners as far as giving really clear guidance. And I point to the long list of, if you read the L1B memo, they include a long laundry list of different types of evidence that a practitioner can submit to the agency. Anything ranging from patents to payroll records to statistics about the company. I think practitioners are afraid that this may be used as a checklist for adjudicators and adjudicating the L1B cases. On the other hand, we also see this as becoming perhaps turning into the boilerplate RFE, in which practitioners are going to have to then, I see Angela going to the mic, so basically tell their clients, hey, there's a long list of items here, and we need to respond to them. And I know the memo only says that you could pick one or maybe 3 or 4 could satisfies your burden of proving specialized knowledge. But this long list of evidence would basically, as being counsel to my clients, I'm going to say we should try to respond in each and every item. We don't want to be deficient. We don't want to get a denial because we missed addressing one of the documents on that long list. So I think it's going to add to voluminous amounts of paper to file and respond to L1Bs. Angela, I see you're at the mic, but I'll defer that to our lovely moderator.
Okay, Angela, I'm going to give you one chance, and then you have to wait like everybody else.
Can you hear me? Can you hear me?
Yeah.
Okay. I'd like to address this to the USCIS and DHS personnel here, our esteemed colleagues, because I was rather disappointed in the memo, both in its proposed and its final version. One of its deficiencies is that it does not offer examples of what would be found to be acceptable, even though that was recommended in the comments by many people. Another is that I believe there's a potential trap here that I want to alert you to, so that if you see a pattern of this happening, perhaps you can nip it in the bud. And that is that, on the one hand, it is said, consistent with the standard of proof case, matter of Chawathe, that a single document could be sufficient to allow for approval of the benefit sought. And on the other, it offers a laundry list of illustrative types of evidence, some of which, such as payroll records, can be very burdensome, and others of which are not really within the availability of the petitioner to establish. And if an employer were to submit a very well-crafted, articulate, and logical and reasonable single letter, and they stand on that letter and do not indicate in an RFE response that that's all they're going to submit because that's sufficient, is the agency going to deny that case, or will there be an insistence that some documentation in supplementation be submitted so that the quest for an inconsistency can be cited, and then precedent decision that says, well, we see an inconsistency, therefore we can discredit everything you have said. It seems to me that the latter is what's going to happen. People will be intimidated into submitting evidence. Some non-material inconsistency will be cited, and adjudicators will go forward and deny on the basis of being able to discredit all the evidence. So can you address my concern about the foreseeable outcome of this memo?
I can start, and we can
Sure.
all chime in.
Yeah.
We definitely considered the comment about the examples, and so we had significant discussion about that. And it sort of goes to this point you make later about the laundry list of documents. And the problem is if we provide an example, there is a fear that that would be relied on, and if it doesn't fit that example precisely, you fall into the same trap. So for that reason, USCIS decided to keep the examples out of the memo, and will use examples in training adjudicators and actual case studies, but we didn't want to force a reliance on the particular examples.
Right, and we're trying to get away from putting examples in policy memos for the reasons just stated by Chev.
And for my part, I can state that in terms of the training that was provided, there was absolutely no emphasis on trying to entrap someone based on what they did or did not submit.
So it's okay to submit a single letter, and if it's a good letter, it will be approved?
Well, I think that we will make our determination on a case-by-case basis.
But our policy goal with issuing this memo was not just to clarify the L1B guidance and eligibility requirements, but to be as flexible and wide-ranging as we could be. And I think that that's probably the reason why we wanted the laundry list in there.
I think an important point to make is that, practitioners may focus on L1B based on their specific clientele or their industry. But when you think of how you can apply that, apply for that visa petition based on all of the industries in the United States and all the potential permutations of what might constitute specialized knowledge, you really can't, to be fair, just come up with the 2 or 3 things. And I think I can honestly say that as part of our discussions, that we were trying to be very sensitive to that.
Also, Sasha, we're still very young in terms of the adjudication cycle for the L1Bs right now, aren't we? I mean,
yes.
You're talking about 2 months. So far, we have, what, 2 months worth of adjudications?
Well, I think that, you can look at how guidance gets implemented, and I really think that the agency did a really thoughtful job in the way that this guidance was implemented. I mean, we did allow for the public comment, but there was a lot of work going behind the scenes, and we were able to deliver training and have roundtables and discussions before the guidance took effect. And you are correct. I mean, it was just in August that the memo took effect, but we did gather our resources from across the 2 service centers that adjudicate these petitions. We invited in DOS staff and CBP staff. We had roundtables, trained the trainer events, and then exported through those people training out at the individual centers. And so, to be honest, I'm very proud of the way that we sought to be consistent and have a good dialogue with the full range of folks who will actually be analyzing these petitions as they move through the process.
And Sasha, if I could just pick up on that comment about the notice period and the comment period. For the past 3-5 years, as this was brewing, the service has been very engaged with the stakeholders. You've been very engaged with the employers. You've been very engaged with the employees. You've been engaged with labor. So I know all those conversations have taken place. That's been all incorporated into, the 15-page memo, which really pulls all of this guidance together into one 15-page document, which is now going to govern what specialized knowledge is and isn't. But, when you look at the statute, specialized knowledge is vague, intentionally so. So it's very difficult to read that memo and say, well, you guys missed the mark. This doesn't tell me what specialized knowledge is. Well, it's not going to, intentionally so, or at least that's really my perspective on that, because it is an evolving concept. And from an industry perspective, technology evolves. The specialized knowledge that goes into technology evolves. So what specialized knowledge, according to this memo now, is not going to be specialized knowledge next year. I mean, just look at how fast industry and innovation is ramping up. So I think, again, I'm not putting words in your mouth. I wasn't involved in the drafting of it. But again, too soon to tell how it's going to work out. We're only 60 days in a memo that we've been waiting years and years for. So I think we do have to be a little bit tempered in how we wait for it, and also rely on the service to ensure that, and this goes to your comment, Sasha, that the training is going to be evolving as far as I understand. And you are going to take those examples. You're going to continue to engage with stakeholders to understand what the issues may be and how that could be incorporated into more fine-tuned adjudications.
Fred, last words, and then I think we need to move on.
Yeah, I'd like to pick up on that. So the Ombudsman's office for several years now have been calling on USCIS to actually offer case examples when they do come out with the L1B guidance. And I understand, for all the reasons that you mentioned, that possibly by having case examples in some industries and not in others, that's unfair. I also understand Peter's comment too, that case examples could become outdated potentially very quickly. I want to say that the Ombudsman's office met recently with a service center, one that does adjudicate L1Bs, and there is an initiative that's currently in process and expects to be completed soon, where they are putting together a case examples for training, and that they're going to use those case examples, in fact, cleared at HQ and then moved downstream. So while it's not in the guidance, they're moving forward, and I want to applaud that.
Available employer?
Probably.
I'll leave that to council.
It's still in draft, I guess.
I don't think drafts are releasable under FOIA. Sameo. AAO is unfortunately not able to be with us today, so Chev, you are the closest thing. Can you remind us of this decision?
Oh, I'm sure you haven't forgotten. On April 9th, the AAO issued a precedent decision and held that a change in the place of employment requiring that a new labor condition application be certified to DHS is a material change, and therefore an H-1B employer is required to file an amended or new H-1B petition. So to clarify, like solely obtaining what people used to do in the past, solely obtaining a new certified LCA from DOL and posting that at the new place of employment is insufficient. And we heard a lot of comments and concerns about this and the implementation of that, and USCIS then issued guidance. We had draft guidance and final guidance taking into your concerns about compliance with the Simeo solutions. So what we had said in that guidance, that if the petitioner's employee moved to a new place of employment that was not covered by an existing or approved H-1B petition on or before the date that the AO decision was issued, the petitioner may choose to file an amended petition by January 15th, 2016. We also said that USCIS will generally not pursue new adverse actions based solely on that change in location. However, any adverse actions that had been instituted beforehand would be preserved. If a change occurred after April 9th, 2015, but prior to August 19th, 2015, the petitioner must file an amended or new petition by the end of the safe harbor period, which is January 15th, 2016. And any changes that occurred on or after August 19th, 2015, the petitioner must file an amended or new petition prior to beginning employment. I think it's important to say you must file before beginning employment because, as you know, it's just the proper filing of an H-1B petition that will enable someone to work.
Peter, from your perspective, what are the implications of compliance with the decision and its interpretation?
Sure. In CISOMB, again, from an employer perspective, whether you're a small employer that has 2 H-1Bs or a large employer that has 10,000 H-1Bs in the U.S., it's a game changer because you now have to file an amendment every time you have to file an LCA. So what that means is, you're risking the RFE, you're risking denial, and in perhaps what I would call sometimes an inconsistent adjudicatory trend, there's also the cost associated with that. And if you read CISOMB strictly to interpret it to mean that it's all about the notice requirement, so CIS, rightfully so, wants to be able to tether the LCA, the employee, the beneficiary, with that H amendment in a particular location. You certainly get that. If it is just a notification provision, then I would say that's like the AR-11 program on steroids, right? Really good steroids. Or is it to re-adjudicate each and every H-1B case, which again I would suggest doesn't necessarily or goes above and beyond achieving the objective of the case, because now you're taking otherwise strained resources, strained costs, and essentially re-adjudicating each and every H-1B that's already been approved. And the only change, albeit now material, is the location. So that's the dynamic that companies are trying to balance and trying to struggle with now as they operationalize mail.
Well, as speaking to the point of operationalization, if that's a word, what are some of the operational challenges that you, you representing an employer, must experience?
Well, certainly the risk of the RFE followed by a denial, that could put somebody out of commission, force an employer to fire an employee, send them back home after they've been in the United States for 4 or 6 years. And then, of course, there's the cost piece, and that can't be overlooked. And oftentimes when companies talk about cost, it's a matter of, well, you're a multi-billion-dollar organization, take the lump and move on. The cost associated with CISOMB, and this is just talking to peers at similarly situated companies, perhaps a half a dozen large U.S. organizations that have a mobile workforce. They have a mobile H-1B workforce. It's over $100 million, and that's just 6 companies. Multiply that by 100, and you're talking billions of dollars of additional costs from a organizational perspective, whether it's the filing fees associated with petitions, the legal fees associated with the petitions, or just the management internally of the headcount that has to be added, and the policies that have to be developed, and the time that it takes to put these programs into place and ensure compliance.
Fred?
Peter, can you talk about the mobile workforce, though, a little bit more? I mean, it seems like there are many enterprises that have their employees in movement even within a year, 2 or 3 locations. With adjudication speeds the way they are, does that mean filing, premium processing, and how does that all fit together?
Well, the premium processing question is certainly one that a lot of companies with I call uber mobile workforces is tackling right now, because under CISOMB, it's possible that you could have, and I'm speaking from a management consulting firm perspective, one management consultant who has to go to New York for 3 months, Chicago for 3 months, Los Angeles for 60 days, then to Dallas, then back to New York. So that would suggest almost 6 amendments to be filed if you do normal processing. And right now, the delays for normal processing are at about 5 months. That means you can have stacked 6 H-1B amendments. You can have RFEs on each of those associated amendments, challenging the right to control that employee in each particular location. And if one of those RFEs is denied, or perhaps that person's already at the 3rd location on his or her annual itinerary, then what does that mean? Where does that person then go? Do they have to go back to the original location? Can they go to a subsequent location because there's still a pending amendment, or do they have to go back to the most recently approved H-1B amendment petition location? So those are the things that companies are grappling with right now when you talk about, again, an uber mobile workforce.
Right, and the fact is that there's no actual real answer out there that we're aware of at least in terms of, what is, there's the most conservative position, there are other positions. Marcine, I think that proposes some, significant concerns for ethically for council to consider. You want to touch on that a little bit?
Yeah. So basically, when we think about where we have to file a new LCA, then an H-1B amendment, and the costs are huge. Sometimes, it's a big company, but what happens if it's a small company? To be doing this could mean, thousands of dollars, hundreds of thousands of dollars for a small company that happens to move their employees to different locations. So strategically, we've changed the way we're thinking, and we're saying, hey, let's try to put as many known work sites as we can on the LCA to cover any future movement that we know of. But I think what comes into play is when we try to think of, a future work site, a known work site, we're thinking of, wow, speculative employment. Am I thinking of a site that the person may not work at but might work for? So we sort of have, we have to kind of draw the line and say, yes, this is a known workplace that the employee is intending to work at without, overstepping our bounds to saying, well, I'm not really sure, but maybe, might be, maybe not. So we grapple with that. And also, what about the employee? So under this, under SEMEO, if the employer does not file or file timely the H-1B amendment before the employee moves, then the employee is out of status. So then even if I'm counsel and I'm not representing the employee and I make it clear to them, do I have some kind of duty to at least inform them that, hey, if you change your employment site, should you, make sure and contact the company and ensure on their end that they did what they were supposed to do? On a practical level, I've changed my cover letters that go out for the employees that say, hey, here's your H-1B, all the things that they should know. And in there, it actually says if you change locations, you should go talk to your employer and make sure you do that, because it could mean that you would be out of status if the employer does not actually timely file that H-1B petition before you move. So these are some things that, I think practitioners are grappling with right now.
Okay, Angela, before we take you, I'd just like to hear from our USCIS colleagues, particularly Chev. Do you have any reaction to some of these concerns? Anything you'd like to think about, perhaps?
Well, as I know our director said this this morning, and USCIS take that very seriously, we are always open to hearing concerns and to change things as necessary or if they require it. So please bring those concerns to us. We do consider them. It does take a lot of time and effort to change things, as I know if Esther and David sort of explained a little bit of the process of how things happen within the agency and within the department. But everyone, all of our leadership, everyone is open to hearing those concerns.
And I would add, not just concerns, but if you have questions about clarification of our policy, about what happens when someone moves and then their petition's denied and there's been a bridge of petitions or something like that, send those questions to us and we'll parse through them. So,
if I may, was there any reason why there wasn't prior notice on this decision? With other movements, big movements that USCIS has done, there's been sort of an outreach effort through published guidance, or amicus have been solicited. In this instance, the entire community was taken off guard, and I'm just curious, is anybody able to address that today? I know it was an AAO decision, so
Right. I mean, I can only speak for us in policy, and we obviously knew that the precedent decision was in the works, but we were not aware of the impending publication date of the decision. So, just being honest about that. I don't know if you guys were aware that it was going to be published in advance, Chev.
I think the process it goes through to the review, it kind of happened. Maybe took some of us a little bit unawares, and I think we have learned some lessons about how, if we do have future precedent decisions that come out, how we need to sort of work in tandem with guidance and things at the same time. It was certainly a lesson learned from this decision.
I mean, we saw a scramble a bit afterward, right? We put that draft, and then we came out with other guidance afterwards, so it was...
We said it was
we had to
effective,
catch up.
the guidance was effective immediately, and then we backed off of that and accepted
Yeah.
comments
And-
on it. And
Thank you.
So absolutely,
Yeah.
it was a lesson learned.
And
And
it
you
is a
allowed for
learn-
comment too, and thank you for that.
Yeah,
I
and
think-
we, no, that was definitely appreciated, and I think, one of the things that we as, your stakeholders look at and say, are constantly, well, why can't they do things faster? Why can't they do things faster? But at the same time, we also want them to listen to us and to take our comments under consideration. That is a long and arduous process. And so the two don't necessarily work in tandem. It takes a long time. I think David and Esther described the process very well. But that process applies across the board. We asked for the ability to put input into these into the policy guidances and memos, but that just adds a lot of more time to the process. So I think we have to acknowledge and be appreciative of the fact that sometimes when something comes out like that, that is a surprise, that not everything has been worked out and thought through, and so we appreciate the ability to have a continuing dialogue on this. Yes, Angela.
I actually like to follow up on what's been said here and offer a few additional observations and invite your comments. The AAO has acknowledged that they, in fact, speak with the Office of Policy at USCIS, which is an odd thing to do for a supposedly impartial tribunal. That's not done normally, that there would be ex parte communications with one party to the proceeding. And it's odd for me to see that the decision itself cites a 1998 proposed rule that was never finalized and cites only part of the rule, part of the proposal. It does not comment on the fact that in the consulting business, situations can change in a day. And it would seem to me this is not good process, to throw people off internally, to throw the community off externally. And if you want to make such changes, follow the process. Finalize a proposed rule rather than tell people who innocently relied on a letter from the legacy INS to a stakeholder group, not to one person, but to a stakeholder group, that their reliance was misplaced. This has been a very sad chapter in our history of iteration of what the law requires and what the procedures are. And so I would suggest that if, at the very least, the AAO is going to issue a decision, it should invite amicus briefs, because it took us by surprise. The particular party involved, Simeo, the company, was small in comparison to the significance of the decision, and there would have been amicus commentary. And moreover, if you note, Simeo is a certification. It is not an appeal. So this was something that the agency reached out for internally to develop as a policy. Inappropriate way to do things. So I'd like to know, what are the lessons learned from this and what are the best practices in the future?
Well, duly noted, Angela. I appreciate that. One of the best practices would be that a letter should not be issued by whatever level USCIS official to a certain stakeholder group, which could be argued is in contradiction to our regulatory language, which requires an amended petition be filed when an LCA is required to be filed to cover a new geographic area. So there was a lot of confusion for a number of years because of Efren's letter. I don't mind saying his name. He's my former boss. But I mean, that would be my response.
That's the only thing that's learned?
Yeah.
Well, I will add to that and say that that precedent decision was a long time in the making. Since then, we have gone out, as you've said, with amicus on other issues that we are considering. So that is a move, that is a trend that we're going to, where there are issues that we know will likely be controversial, to seek the input. So we are changing process, and I think to your point about sort of consulting with policy, I think there is that AAO memo that talks about that AAO doesn't announce, AAO non-precedent decisions don't announce the policy, and they do not speak as the policy or the legal, but they implement the agency's policy and legal interpretations. So that's.
We know that doesn't mean anything because
Well,
in the past, non-precedent decisions have been turned into scripts for adjudicators to deny.
And that is the
in the
reason.
GST case, and it's happening in that 48-page non-precedent
But that's the
H-1B
reason
case.
we issued that non-precedent to stop that, and that if that is happening, that we should be alerted of that. That is the goal of the agency is to not have people rely on the non-precedent decisions.
But your adjudicators can.
No, the memo says it's not to be relied upon.
No, it says that they can use the logic of it if it's appropriate in the circumstances. So they've got a canned script on how to deny a case.
Well, I would venture to say on the flip side that a lot of practitioners read the non-published decisions that are posted and also, subscribe to logic in other cases. I mean, I think it kind of cuts both ways. But I can tell you that in terms of working with the field, that we emphasize at every turn that an unpublished decision is not a binding precedent decision.
Well, I can suggest another lesson learned, and that is that the service should open up its process when it's presenting to the Attorney General a request for designation as a precedent to allow public input as to whether that's a good case for a precedent decision. Because that doesn't happen. That was closed to us as well. So there were 2 times in the course of Simeo that the public was shut out. And we then received a fait accompli that created all the questions that Peter and Marcine have identified. So it's been an embarrassment, I think.
I appreciate that. I'd also make a final note that the Office of Adjudications Chief Thomas Cook, I can't remember when he issued the official policy memo, but it did say that letters written by certain CIS officials to the private bar or private stakeholders are not binding. So I'd make that point as well.
So our bad.
Not saying that, but you don't hear about any Kevin Cummings letters being issued. So.
We hear Kevin Cummings statements and engagements.
Yes, you do.
You do. You do indeed.
Those.
Well,
I know.
in the interest of time, gentlemen, we've got a lot more to cover, so I'd really like to move on. Fred, in 5 minutes or less, can you give us the latest on EB-5? Will we have an EB-5 program after December 11th?
Yeah, I can do it in 5 minutes or less. Yes, I think we will have an EB-5 program after December 11. So the original sunset was September 30. Congress kicked the can down the road. It's now December 11th is the new sunset date. The Regional Center program's been around since 1992, and it's been continuously reauthorized, sometimes in short gaps, sometimes in longer spells. It seems to be tied to E-Verify, seems to be tied to Conrad waivers, J Visa Conrad waivers. So I'm pretty confident we'll see one. There's 4 or 5 bills right now that are circulating on Capitol Hill that are each of which have different nuances to them. So I don't want to try to cover those nuances, but in large part they cover issues of increasing the threshold capital contribution amount somewhere in the a couple $100,000 to 300,000 or somewhere in that zone, both on targeted employment areas as well as in the regular investment threshold. And there's also, so money's an issue. How the agency determines targeted employment areas is an issue. What criteria they'll use for many regional centers who are trying to actually configure their programs and projects within urban zones. That's mostly where the targeted employment area issues are coming up, and how do they scope in appropriately high unemployment areas in order to achieve that. And there's different discussions about how that's done, and there's some discussions about eliminating targeted employment areas altogether. So, that's an issue. Of course, retrogression has reared its head, and so there's questions of, you know, what is the agency going to do with retrogression? But there's also the statute, you know, typically if Congress will say something about retrogression, then that's what binds the agency. And so if Congress deals with retrogression or grandfathering specifically, it takes the issue out of play with CIS. So that's in play, or that's one of the issues. Fraud and integrity is certainly right at the top. The program has been around since '92, as I say. A lot of projects have been on the books. A lot of regional centers on the books. A lot of them are defunct. A lot of projects have never completed. There's been scandal that has you know, popped up from here and there. It's not widespread, but there's been scandal. People have lost millions of dollars. Immigrant petitioners have lost their chance at a green card. So, you know, there's a lot of tightening going on. There's national security interests that now are in play that weren't in play before. So there's a lot of emphasis right now in terms of the EB-5 program that on the Hill that focus on fraud, integrity of the program, you know, and it's it is important because this is a program that has had controversy in the past. You know, there are people who don't like the program. They think it's buying citizenship or buying green card status, and so it has to be done in a way that's unassailable. So there's more being placed there, more emphasis there. Termination of regional centers is another issue that comes up. Now, USCIS is getting to moving more quickly at terminating regional centers in a formal way. You have to go through a process, and the question with that is, what happens to those individual investors who are in projects when the regional center is terminated, who the project may have been completed or near completion? There may have been fraud in, or there may have been something slow in the regional center, the management of the center, but it has nothing to do with the individual investor. And I think under the current statute, as it's being interpreted, unless that regional center is alive at the time the conditions are removed on status, then they will not be able to achieve final conditional status, and their condition removal will be denied. So it's a real issue. And then finally, there's new guidance that came out in August, so I won't go into that. That's still in the interim stage. It hasn't been made final. The secretary, who we heard speak this morning, issued a directive earlier this year putting into place new protocols for EB-5, which are built-in protocols directed towards USCIS and other DHS components, including CIS, to develop protocols to make sure that the process is free of unnecessary pressures and inappropriate, you know, either favoritism or bias, and that either favors an individual regional center or individual as opposed to others. And so there's building in essentially some more, again, integrity into the process, which requires more documentation by the agency of any interaction with Congress, with the President, with other elements of the government, state and local, as well as individual regional center owners and their representatives on cases and on policy. So we have interpreted that as well in the Ombudsman's office. It applies to us, but we have our own subset of those protocols that, you know, allows for us to because we're not CIS, to be we interpret it a little bit differently for our operation, and we're in the process of finalizing those protocols now, our interpretation of those protocols.
For those of you who don't practice in the EB-5 world, I do commend you to read those protocols because they're up on the EB-5 portion of the USCIS website. It's a very interesting interpretation, and I think a very telling one, of the interaction between the filer and the adjudicator, and it's an interesting view into adjudication policy. So I do commend you to take a look at that if you haven't already. No reason why you might have. So there's your takeaway. Keeping things moving, Fred, can you tell us exactly what's going on right now with the ownership of the I-140?
No, but but I will explain the issue. So the I-140 petition is filed by an employer, and so that's the immigrant visa petition for a beneficiary who's going to come into the United States to work for the employer in either specialty or in various potential strata. And so as it stands right now, USCIS does not recognize the beneficiary of that petition to have a direct interest in the petition. So and there's a reg that's on it. I can cite it to you, but it's just you can find it. But the point is, USCIS does not recognize the beneficiary of an I-140 petition as having an interest in the petition itself.
8 CFR 103.2B, I believe.
103.2A3.
A3. Okay.
Okay.
There you go.
Thank you. So and so where this comes up is with portability, with AC-21, which and the reg preceded AC-21. The individual beneficiary really has a right to port after the petition is approved, and they can port after an adjustment of status has been pending for 6 months or longer. So they can go to another employer. When they go to that other employer, the previous employer, the originating I-140 employer, may no longer have really an interest in defending that I-140 petition. And in some circumstances will withdraw the petition. But where they don't withdraw the petition and it's still out there, USCIS, who's looking back years potentially at an I-140, when finally the adjustment comes up for review, will see something that causes them concern. They want to issue a notice of intent to revoke. That's what happens. It's not an RFE, it's a notice of intent to revoke. And they'll issue it to the former employer, but if the former employer is gone, company's closed, or if the former employer has no interest, they might say, well, I'm not going to spend any money to defend this. I don't really care what happens. The effect of that is the beneficiary of that that approval has already moved to another employer. They don't even know. They're not entitled to notice, or they're not given notice actually at this time. So, and it's really a kind of a disjointed scenario where you have AC-21 saying you can port. You have the regs that say they don't have a actual right in the process as a beneficiary. Courts are split on it right now. The 11th Circuit and the 6th Circuit have ruled that they do have a right. The 9th Circuit, which is typically more employer or sort of considered to be forward-leaning circuit, has actually said no, they don't have any right. It's an issue that I do know that USCIS is exploring. I know there's regulations that are being considered that might do something to recognize more of the beneficiary's interest in the process, but it's all unclear right now. So I don't have an answer.
Well, we know that AAO has asked for amicus briefs.
Yes.
And I know that briefs were submitted. Chev, can you tell us what the agency is looking for from some of these amicus briefs?
Everyone's opinion. No, I mean, I don't think there's a specific thing that we're looking for, and that we are, looking to get all points of view on this topic, because the circuits are split and there are arguments to either side. So I think we really are considering everything you submit to us. So the request for amicus brief was posted in April and the comment period closed in May. My understanding is that AAO is reviewing that now, and should there be a case that allows for a precedent, then we will go down that path.
Thank you. Peter, what are the implications for employers?
I mean, the I-140 is not a joint petitioner filed application, right? So it's the employer owns the I-140, they own the process, and the employee is the beneficiary. Now, rare is it that there are conflicting interests, because it's in the employer's best interest to hire that employee. It's in the employee's best interest for that employer to take the petition over the finish line, and then you can get into the portability components. But with that said, in a highly competitive environment for the best talent, it behooves any company to take a very restrictive position and prohibit an individual, a beneficiary from, seeing documents, getting copies of documents. And, there, of course, needs to be the balance of what's proprietary to the company, what's beneficial to the employee, and, where the two meet. But from an employer's perspective, it really is a balancing act. So, whatever the outcome of the AAO case may be and the policy that's formulated after that, I think employers really just need to make the decision as to where they want to fall in that balance. Are they going to be more protective from an employer perspective? I don't want to suggest that they're chaining an employee to his or her desk, but you also don't want to be so lenient that you're just creating an environment where you as the employer are the training ground only to be poached by other employers who are just waiting for that person to get the approval, and then they're going to take your valued talent.
Marcine, you have anything to say about that?
The purpose of AC 21 portability is that that worker can move to another work site, and since we have to prove it's same or similar, they have to move to a same or similar job. Sometimes you need to know, or all the time you need to know what's on that I-140 petition to be able to show USCIS whether it's a same or similar job that they're moving into. And I think, Fred, you talked about perhaps there's a notice of intent to revoke that's issued maybe years later. Well, it might not have anything to do with the company. It might have to do with something of the beneficiary's own credentials or background or something. So, the company doesn't even need to get involved in it. And it'd be nice for the beneficiary to at least get notice of this and to be able to address it. And in that situation where the company was not even involved with the reason why they might be sending the notice of intent to revoke, maybe they should have the opportunity to answer USCIS. So those are my comments.
There's a way to solve this problem.
Third time, Angela.
Very quickly. I published an article a long time ago that proposed a cell mitosis theory when adjustment portability came into effect. And that is that both parties get the benefit of the priority date and the test of the labor market. And they go their merry way. If you were to do that, no one would get a green card a day faster than otherwise, but at least the investment of the first employer is repaid in some degree. And the portability provision and the public policy of allowing job flexibility is recognized as well. And trying to say it's one or the other is a fool's errand, I think. And there are many instances outside of this where the service fails to recognize that there are multiple parties in interest with a legal interest in the outcome and fails to provide notice. So I hope this is the beginning of an investigation into how can we do justice here, because that's the real problem. It's an injustice to put on the burden of someone who doesn't even know a decision has been issued some urgency to respond when the recipient of the notice could care less since the jerk left. And it's a real problem of justice.
Yeah, I think that it really is an issue that needs to be resolved, because if there is an I-140 that is denied, and that party could then become out of status, right? I mean, that's what they would be, out of status. And if there's no determination of that, then okay, maybe perhaps there's some tolling of the 3 and 10 year bar. But they're out of status. And this becomes potentially something that's not surfaced for many years. And so it is an issue that needs resolution, surely.
Thank you. I hope your cell mitosis theory went into an amicus brief that made it to AAO. That's all I have to say.
Only someone did.
Well, obviously, there are a lot of issues that we haven't touched on. I'm going to do this really fast. I'm going to ask people to start talking faster. Kevin, H4 EADs, I know that was a very long road. Can you briefly summarize it for us?
Sure, I'll talk as quickly as I can. The H4 EAD initiative for spouses of certain H-1Bs started with a We the People petition that was submitted to the White House with over 6,000 signatures. So on January 31st, 2012, DHS announced a series of future administrative reforms, which included providing work authorization for the H-4s. So we published the H-4 EAD rule on May 12th, 2014, and we received nearly 13,000 public comments on it. So That was a record for comments for a USCIS rulemaking at the time, although we expect that record to be broken really soon when we issue some of these other EA rulemakings. So get them in there, you guys.
Are you challenging the stakeholder community?
Yeah.
Okay.
Yeah. So anyway, we considered those comments, but we actually did adopt the final rule as proposed after all those 13,000 comments, and it published its final on February 25th of this year, with an effective date of May 26, 2015, and we're really proud of this rulemaking. We felt like it was needed. I can't tell you how many thousands of emails I received personally from H4s and people that were just like, look, I've got this great education, I've got a master's degree, and I can't work in the United States. And so we feel like this rulemaking being finalized has made a real difference in the lives of thousands of people. So.
Sasha, do you have a sense of what the filing volume has been?
Well, I can say that the volume of filings is quite a bit less than what was estimated in the rule. I don't have specific statistics, but we have received a fair amount. We put a lot of thought and time and effort working with council and policy to establish some web pages on the website that I think provide a lot of useful information about filing for that benefit. And, and as Chev has indicated, we are, all ears if there are other questions or things that we could provide that would help provide clarity in how to file. An important takeaway is this particular employment authorization is tied to the H-4 status, which is in turn tied to the H-1B status. So it requires a little bit of finesse in that if a 765 is filed for the H-4 benefit, we do frequently have to adjudicate the 129 H-1B petition and the 539 application for the H-4 applicant prior to being able to adjudicate the 765 employment authorization request.
We also learned when we were visiting various service centers over the last several months that they're coming in both ways. They're coming in attached to an I-129, 539. They're also coming in as standalones. And, depending on how the application is filed, it can take two very different paths through the service center. So it's
That's
something
true.
As people wonder, well, what's my processing time? It's totally dependent on how you filed, correct?
Yes, it would be very difficult at this point to establish what a standard processing time would be given the variances in filing.
Yeah, just a nuance on that. So if you filed it concurrent with the I-129H, they'll both be adjudicated together, is what we were told, as opposed to a change of status, as opposed to standalone. That's what we were told, anyhow.
Well, they are adjudicated, as a group. There are instances where there may have to be an RFE on a 129. Sure. There may be instances where an RFE must be issued on the 530. Make every effort to adjudicate concurrently where that is feasible. But that is not always feasible given the facts in a case. So it just adds to a challenge in that regard.
Thank you. Okay, on F1 OPT, well, you heard David Chihulian, Deputy General Counsel, this morning. It's under comment period, so we're gonna skip right through that one. What does the coming year hold? Obviously, there's a lot on the plate. Part 3 of the November 21st directive was to USCIS was other regulatory or policy changes to better assist and provide stability to beneficiaries of approved employment-based immigrant visa petitions. Kevin, Ciro, can you tell us in general terms what's being done to affect that piece of the directive?
Sure, we're working on a whole bunch of items that correspond to that. We are looking into our policies regarding what happens when an approved petition is withdrawn or the business terminates, so that maybe that beneficiary can still use that petition for certain purposes. Obviously, we're clarifying our guidance on portability. So what constitutes a same or similar job occupation for people who are porting under 204J without INA under AC 21. We're clarifying the retention of priority dates in a number of situations for revoked I-140s. and we're looking into policies towards conferring an employment authorization document, open market, to certain beneficiaries of approved I-140s. And per the Visa Modernization Report, we're working on a number of other things that kind of correspond to this, looking into some of our non-immigrant categories, of whether there's a grace period to be allowable in certain situations. That's one of the mandates of the Visa Modernization Report.
Thank you. That's a lot to cover in a year's time.
Sure.
So you're going to give us dates as to when we're going to expect to see each and every one of these?
Well, a lot of this stuff is currently very far along, and some of it's embodied in the regulation that we talked about earlier, the AC-21 regulation that also has a lot of other related provisions that deal with increased worker portability, which was the intent of AC-21, of course.
Exactly. Some of us actually still remember what AC-21 said. Surprise, surprise. It's very good to hear that things are moving far along. Again, because it's a lot of it's tied to a regulation, you'll be issuing a notice of proposed rulemaking?
It would be a notice of proposed rulemaking, and I can't comment on specifically what's in it at this point right now because it's not cleared yet, of course. But it would be an NPRM for everybody to comment on, and of course we'll consider your comments in issuing the final rule.
Well, good luck with that.
Thank you.
I'm sure you're looking to break that record of 13,000.
And we're going to need detailees to help parse through some of the comments.
Yeah. And as of today, actually, with regard to the STEM OPT rule, I just checked the docket this morning on regulations.gov, and there's nearly 7,000 comments submitted for that already.
Oh, boy.
Oh, wow.
Good luck reading and responding to all meaningful comments. Okay, the directives also talked about national interest waivers, guidance or regulations to clarify the standards. Chev,
Yes.
What's meant by that?
Well, I think one of the directives from the Secretary was sort of to address the underutilization of the national interest waiver program, and that's one of the top priorities. We are looking at our policies and looking to see if there's how we can clarify the standard of so that entrepreneurs and inventors and researchers are able to better utilize the national interest waiver. Fortunately, the Secretary has very broad authority under the national interest waiver statute, so we are looking at that and looking at our precedent decision in that area and seeing what additional types of guidance we're able to give.
Thank you. We only have a few minutes left. I promised I was going to leave time for questions, but Angelo just had lots and lots. So I'm gonna quickly turn to the mics and to some questions I've already received. And this is virtually anybody on this can answer this. This is directed to USCIS policy, but I'm sure that SCOPS can also address this. Why are service centers re-adjudicating H-1Bs on extension and saying that they're not a specialty occupation in the extension? I mean, that's a pretty broad
Right.
issue.
Well, it's kind of hard to understand from the question exactly what the fact pattern is in the petition. We do a lot of work with our centers in terms of adhering to guidance on, the policy of not looking back at a prior decision, unless there has been one of those three factors, presented in the case. And I know for the sake of time, I'm not going to belabor that, but I'm not sure why in that particular case.
Okay, I think that the question is more generalized in terms of,
Right.
when you've already filed an extension, you're getting an RFE now questioning the specialty occupation. But I agree with you. I mean, there's guidance out there on this point, and
Right.
clearly it has to be. Anyone else on the
If
panel?
we're not adjudicating to the standard of our deference memo, then we want to hear about it. So please send those comments to us. Carlos from Public Engagement is right up there, so just talk to him afterwards.
And to be honest, there are instances where those issues have been raised to SCOPS in particular cases, and in some instances, it did appear that the officer was not properly applying the deference memos. In other instances, there had been material changes or other factors in which, an adjudication based on the specific merits in that extension petition, that it was an appropriate course of action. So it is a fact-based adjudication.
Thank you. How much and what sort of training do adjudicators receive with respect to the preponderance of the evidence standard?
Well, I am proud to say that this year we worked collectively across all of the centers and with other components in USCIS to develop preponderance of evidence training, and that training was delivered universally at all the service centers, and it is a component in every individual form-type benefit training that the centers do. And it is an ongoing source of discussion. So I think everyone is well aware of the standard of evidence that we use typically in adjudicating cases.
And I think that the point of the reissuance of the training and the ability to retrain on some of those issues, I know we've seen some improvement in some of the RFEs that we see across the spectrum, not just in terms of the employment-based issues. Please, identify yourself and ask a question.
Sure. You have more questions to ask them?
No, go ahead.
Okay, thank you. Well, it seems like I'll have the last word then.
No, we got one more. We have time for about 2 more questions. So.
Okay. Well, I have a couple of observations and as well 2 questions. But before that, my name is Aman Kapoor. I represent Immigration Voice. We are a group of skilled immigrants who are already here, waiting in line for green cards, and we have 100,000 members. We represent almost 1 million people who are already here, legally present, waiting for the green cards. Before I ask or share my observation, I need to ask everybody in the audience, is there anybody here who represent American workers? Any organization? Okay, which one is that? Okay, is there anybody else here? And the reason why that is so is because American workers and Americans are paying taxes so that CIS and DHS would do their job. I didn't hear a word about displacement. I didn't hear a word about rights, immigrant rights. I didn't hear a word about exploitation and abuses of immigrants when they come over here and they are waiting in decades-long backlog. I didn't hear a word about that in this entire conversation. This conversation was about employment-based, isn't that the subject of the conversation?
That's
and now,
subject of
I didn't hear anything about displacement. You have this report in which you have published data about the L1B RFE rates. But I didn't hear or I didn't see any graph ever by Ombudsman or DHS about the displacement of workers in US. And the reason why I bring that up is, here is the reason. People need rights. They have been here for many years. They're waiting in green card backlogs. I know, Kevin, you receive a lot of emails from people who are waiting in backlogs. Thank you for doing EADH4. But why is it taking 1 year for 140 regulation? And I think the only motivation right now to do EAD 140 regulation is because it's about 1 year to when the president announced that that fix is going to be coming in. It has been 15 years. 2 administrations have not defined what is same or similar. Just doesn't make sense. I think the gentleman over there, the one who asked the question earlier, his concern was submitting documents is burdensome. And I think Peter earlier mentioned he wanted Uber and mobile workforce, which is fine. But what about the workforce that already is there who wants to change jobs? They are unable to change jobs. They don't have rights. And how long can you continue to do this? Now, even with the EAD 140 regulation, you would have 1 year wait time. That's what we are hearing. Why 1 year wait time for EAD for 140? Undocumented, DAPA, DACA, they're not having to wait for 1 year to get their EADs. And these are people who have approved immigrant petitions. Why would they have to wait 1 year? Anyway, companies are filing their green cards after 5th year. So by the time they get to the approval of 140 stage, they're already 7th year into their employment. And now you want them to wait for 1 more year? That means 8 years they're working for the same employer. Even Saudi Arabia doesn't have this requirement, that before you get a EAD, I mean, this is not a laughing matter. I mean,
Aman, I appreciate your comments. They're very apropos, and we understand the frustration that's there.
No, I don't
But
think
no,
you,
no,
because when you invite people over,
please.
if you look around this room, everybody's a lawyer or somebody
Please.
who profits from this business of getting more people from outside. You
Aman,
don't talk about, no, let me
please.
finish, please. Let me finish.
No,
Let me
please.
finish, please.
Please,
You've given
this is an
Angelo
open.
3 times, you've given Angelo 3 times to ask question. If you would not let me finish my question.
Aman, we asked for questions. If you have a question, can you
Yes,
please
yes, I do.
enunciate the question?
And please let me, if you would let me.
Please.
So now, when you're making these workers, around 1 million people in this country who are living like indentured servants, they don't have their rights, and you do this visa bulletin game, and now this EAD for 140 fix is coming up, and we are hearing that that will be under only extraordinary conditions. The only handful of people will be able to apply under extraordinary conditions. Why do this 1-year game and play this around this country where President's executive action is coming up and mobilization will be there and people will have the ability to change jobs, and in the end, only handful of 100 of people will be able to apply for EAD? My question is whether there is going to be an extraordinary condition in EAD for 140. And thank you.
I would ask that you wait until the rule publishes, and then you'll know what's in the rule, and then please submit a comment to
And
the
you
rule.
will submit, I'm sure, many comments.
Well, we
Because
absolutely will be.
There's a lot of speculation as to what might be in the rule. We can't comment on specifics with regard to ongoing rulemakings, but as David Shahulian said this morning, you know, our rulemakings are a priority, and they should be out soon.
Immigration
Very
is,
soon.
okay, immigration is not about getting people with less rights from outside and to displace American worker. Immigration is about getting people over here and make sure that they have rights. All that you talked about, every subject matter was how to get in more people from outside. When are you going to talk about the rights of people who are already here? When can they change jobs? They don't even have access to their own paperwork. Peter over there representing industry was saying, well, they should not have access to the paperwork. EAD, while I-140s it's an immigrant petition. How can it be not belong to immigrant? It's not an employer petition. It doesn't belong, the name of the petition itself is immigrant petition. How can it not belong to the immigrant itself? Thank you.
Thank you, Aman. On that note, I think that we are done. Thank you very much, and we appreciate your time.
figured you probably had.
How's that? Everybody does need everyone that's there now. I could say like the last 5 to 7 years are people that I know personally agree with the same things. Before then, I wasn't so sure. Government is a slow hog. Even though, like literally, like this last few years, you know what I mean? It's like, it's not for people not like all of us, like zero and seven. Yeah, so it's not for trying. It's great. I'm glad to see the people. No, I like all these people. I trust these people. So that's good. They're good. Well, mom, yeah, mom's no, it's okay. Okay, mom's okay. Mom's doing well. She would sing. Yes. In the same house? Yes. Oh my goodness. She's very active though. I mean, she really is very active. She's fine so far. So, I mean, for a few years down the road, we'll have to talk to her. Yeah. So we have to ask her. Yeah, so she's just trudging along. I wish she would just get more involved in getting outside of the house and just get activities and stuff, you know? Right. She has a much busier than our life. Oh yeah, no, I mean she is like every weekend she's at someone's house, and now Raman has her kids, and so has everyone. So she goes to their house for lunch every couple of days. They come over, and so the three of them keep each other company a lot, which is really nice. And she just like needs to take a computer class or something, you know, just join this gym. The gym, that's what they go to. Your dad was always sweet. Your dad is well,
He goes to the gym. We're not sure he actually works out at the gym, but he goes. I mean, they have a gym.
I mean, they're right.
They live in Nashville, but they have a gym. They go hang out.
Airs maybe, so. Okay. And do you want us to do self-intros, or are you going to?
They have the bios, so I'll do a little bit of an
Okay,
intro for each of you, and then we can.
We'll do that at the end. You know, we'll run out of questions. I'd like to tell you about myself. My name. And I look great on camera. The camera loves me.
That's right. Is everyone having a good time?
Go back and work on the rules.
I thought I'd keep this so I was aware of the time.
That's a good idea. Can I see if yours bends further? I have a broken
I don't think I'm going to take 10 minutes, so don't worry.
Sorry?
I don't think I'll need, well, who knows?
No, I think switch if you like. Yeah, thanks.
But hopefully, I mean.
Haha. Should we like test this? I'm really short, and so I need this closer to me.
Thank you very much.
Got it?
It's like fall down the stairs.
I will try to cough away from the mic.
Really, there's.
All right, see ya. Thanks, Chef.
Oh, no. That sounded painful.
Are you sure?
Yeah, I think it's this because I almost tripped when I was coming down to give my question. It's these little panels. Not like
I've had this for like 2 weeks. It's just one of those dry hacking coughs that just won't go away. Maybe even fall allergies, who knows?
I've heard a few allergies. 3:15, right?
Yep.
Okay. Okay, good afternoon, everyone. Thank you for sticking with us. A lot of information covered, a lot of good conversations and information shared from the Ombudsman's office, from DHS, from the components within DHS and private practitioners. So we appreciate the conversations and discussions and hearing from each of you at the various events throughout this day. My name is Carrie Anderson. I'm with the Ombudsman's office as an assistant chief of casework, and I work primarily with the employment issues. Today, I will be covering the panel on 765 employment adjudications. We have a great set of panelists, which the bio handouts in your folder explain their illustrative and impressive backgrounds. But I'll just briefly introduce. To my immediate right, we have Paul Mayani, who's a solo practitioner with extensive experience representing large and small businesses, as well as individuals in employment-based immigration matters. Next to her is Emmett Soper, who is an associate general counsel at EOIR's Office of General Counsel since 2012, and is the subject matter expert on asylum clock issues relating to the Immigration Court and Executive Office for Immigration Reform. And next to Emmett is Deepa Bijpuria, who is a senior staff attorney at Tahare in Baltimore, representing women and girls fleeing violence, and serves as the liaison for the Baltimore Pro Bono Network. So thank you, everyone, for being on this panel and participating today. Just as a little housekeeping, if you have questions, feel free to bring them up to me. As the panelists are speaking, I'll either try to interject the question, or else we'll also cover it at the end when there'll be opportunities to ask questions at the mics. So, let's see if I do start. All right. So, I need to also explain. So, USCIS was invited to participate on this panel. However, because of active litigation, they were unable to participate. But I will be processing guidance that USCIS has provided the Ombudsman's office in conjunction with our annual report to Congress. So our office has done quite a bit of work and engagement with USCIS to understand their employment authorization processing. And so this is information that our office has obtained from USCIS in the context of our annual report and our publications to Congress and the public. So, as most of you know, and I think the room's probably full of seasoned practitioners and people who understand the employment authorization, the Form 765, the application for employment authorization, accounts for about 20 to 25% of filings submitted to USCIS each fiscal year. This fiscal year of 14, it was 21%, which is pretty significant and explainable in part because employment authorization is an ancillary benefit that attaches to a lot of different applications, from filing an adjustment application to deferred action to an asylee or a person applying for asylum. All have benefits that then allow them to request and apply for work authorization with USCIS. Now, unlike a lot of the programs within USCIS, the employment authorization application has a processing
requirement, which is quite different from other applications and a significant responsibility for USCIS when considering it makes up 20 to 25% of their application filings. 8 CFR, you can see the citation there, requires that the agency adjudicate most work authorizations within 90 days of filing. Now, if they don't, in that same section of the regulation, they're supposed to issue an interim EAT, which, if you're familiar with the process, USCIS typically does not issue interim EATs and really tries to adjudicate those cases within the 90-day requirement. And for the majority, they do. However, for those that aren't, we certainly hear from them from the Ombudsman's office, and you also probably experience it as a practitioner. When looking at the data with USCIS's EAD adjudications, there's a couple of trends you can identify from the data. These are representing quarter filings, and this is all public information that USCIS posts on their website. And as you can see, there's sort of a couple things. First, you can see the spikes where there's new program introduction. So, DACA renewal, the issues with the H-4 EADs will also show a spike later in the probably next few quarters. But then there's also seasonality. When you look at Q3 and Q4, there's a common rise of EAD filings, which are issues that our office also has brought and identified for USCIS because we see the challenge of adjudicating within that 90-day process when there is a seasonality issue or a spike in a program filing.
And one really wonders how they could sort of not have noticed this. Let's just say ever since July and August 2007, when innumerable adjustments of status were filed because all of the employment-based categories became current, and then they retrogressed so that the, particularly India employment third, close to the 2007 date. So they know every single summer all of those people, and they know exactly how many they are because they renew them every 2 years, but it's still it's an every other year cycle. So, why aren't they ready for that? Why are they surprised? I mean, it just, and then the students too, of course. The students graduate at about the same time every year. So as you said, there's a seasonality, and sometimes they just kind of look at you and wonder, like, gosh, they have all these cases right now. It's like, well,
and our office certainly has done our part in engaging the agency and engaging the service centers and the National Benefit Center and respond to that seasonality issue. So one of the ways that first, a 765 application can be filed at a service center or a field office. Or I'm sorry, not a field office, but the National Benefit Center, which is under the field office directorate. At the service center, one of the ways that they monitor and manage to try and account for their inventory is in a first-in, first-out processing. And then they classify that by filing date and classification. Sort of another post-adjudication issue that we have seen in the office is with card production, is that once the card, it's approved, you have your approval notice, but there can also be experiences of delays in the actual card production. Which is really what's necessary then to get the benefits of the work authorization, but then also the benefits associated with using that work authorization to either demonstrate eligibility or demonstrate status. So, as Palma mentioned, meeting that processing goal with the seasonality, with the issues of spikes in filing, either because of a new program or because of surges that were started back in 2007. Some of the things that the Service Center does to meet the 90-day goal is running internal queries for pending cases on a weekly or biweekly basis. In those queries, they identify whether it's a case is approaching the 90-day mark or 75-day mark. For the Ombudsman office, we will accept cases that have been filed past 60 days. Because we recognize that there's sort of, if a case has been there for quite some time with USCIS and hasn't gotten the proper attention, it needs to be addressed before the 90th day. And I think USCIS has also recognized that and tries to look at cases before they actually get to a critical stage that would require someone to either stop working or lose benefits. Those queries are added to reports and shared with management and are hopefully assisting the decision-making of inventory and work management. But we're still seeing delays, and we're still seeing some issues that challenge whether they actually can meet the 90-day processing. Similarly, with the National Benefits Center, they do a slightly different process. They do monthly sweeps with the Claims 3, which are used to identify the physical location and the age of the pending case. They also create a report, which then is managed on a 60-day basis. And so they again are trying to get ahead of that 90-day cutoff so that they can meet the actual requirement. So those are all sort of the safeguards, the issues that the USCIS is trying to do within their sort of inventory control and processing control to ensure that they meet their 90-day regulatory requirement. But turning to Deepa and Palma, can you explain what happens to a client or an individual when USCIS doesn't meet that processing goal?
You can take the first shot, Deepa.
Sure. I'm happy to report that, so I come from the perspective of someone who represents victims of serious crimes, victims of domestic violence, victims of human trafficking. And generally, the processing for those EADs is through the Vermont Service Center. So I'm really happy to report, at least in the last year to 3 years, we have not seen serious problems with processing delays. However, at times they happen with individual clients. We haven't seen it systemically. But, I mean, there are serious ramifications. Mm-hmm. Since my clients are extremely vulnerable, which I will discuss in more detail later, I've seen consequences such as single mothers who have fled abusive situations and and their children are financially dependent solely upon them, who are then let go from their work, and they can't support their children, and oftentimes these individuals are also not eligible for public benefits, and it really puts them at risk of everything from potential abusive labor environments to human trafficking, and making them at risk, to be frank, of homelessness.
Mm-hmm. Mm-hmm. Yeah, it's really, and that's, an extreme, and obviously the individuals that really, really, really need all the help they can get, and of course need the EADs, but it's across the board of anyone who needs a work authorization. One of the first things that you lose is a driver's license. Mm-hmm. There are almost all the states tie driver's licenses to the employment authorization card. And when you don't have a driver's license, you either drive illegally or you don't go to work and you don't drive your kids to school and all kinds of other things that happen because you don't have an employment authorization document or any ID. Of course, you lose your job if your employer is actually paying attention and following the rules. And sometimes your children can't be enrolled in school. And again, this is can happen in the summertime is when there are a lot of the peaks of the applications. And so it's a total disruption of individuals' lives. And we bring this up every time we have a liaison with the USCIS policy headquarters. I've been on that liaison committee for some years. And their answer is always, we try really, really hard to meet the deadline. And I'm saying, well, that's very nice. But when you don't, look at all these consequences to these individuals. And they say, well, we do these sweeps every 60 days. You can do an inquiry at 65. And I say, look what happens when you miss the dates. And they say, we try really hard. And so it's like, makes me nuts. I mean, it's just, the consequences are enormous to individuals.
And I think the other, the added issue, I think in recent years, there has been, additional consequences. There's sort of the automatic, work authorization loss and termination of employment if the employer is paying attention. But then there's also now, I think, even greater associations and connection to state benefits, right, to public benefits, to things that are used to demonstrate your eligibility using that EAD. And so, I think there's even an added cost. So with that, I had sort of mentioned before, that the regulation for the 90 days also mentioned the interim EAD. Typically USCIS has stated that interim EADs are not available. They had, the issue with DACAs, applicants wanting interim EADs for delays. Palma, can you sort of make an argument for interim EADs? Because I know one recent announcement for TPS is they've issued interim EADs for El Salvadoran applicants who are delayed. Can you
Yeah,
go towards that?
There's a very easy way to argue for interim EADs. The regulations require them. That really ought to be enough. The regulation doesn't say if you can or if you feel like it, or maybe it says you will get interim employment authorization. There's no maybe about it. And for years and years and years, we did. And then the argument became, well, they aren't secure documents, they aren't this, they aren't that, which is all nonsense and which they shouldn't get away with. I mean, they have done interim employment authorization for Syrians too, as well as Salvadorans, by a Federal Register notice that says the EAD is automatically extended. Take that to your employer, but that's what it says. Use that on an I-9 form. We also, on the, it's not a secure document, I found out last year, which I guess everybody else knew, for green cards. They are actually putting stickers on, which is how we used to get interim EADs long ago for TPS and some other statuses. They are putting a sticker on the back of a green card that says this card is extended for 1 year or something, for example, if it's a removal of conditions or some other reason that you don't have a green card. So they have at hand in the local offices the means to do this. They can put that sticker on the EADs, and they just need to.
Yeah. Well, it's been said a few times that, USCIS adjudicates a majority of their EADs within the 90 days. But for those of the applicants that they don't, and where there isn't a delay in processing due to a request for evidence, there's a person behind that application. So, Deepa, you had mentioned some of the vulnerable populations that you work with and the effects of those delays. Can you maybe go a little broader on programs or program issues that you've seen in your practice that either could use remedies or have effects on your client base that you see through your work?
Sure. So it's really important to understand the types of clients who I represent and what kind of maybe traumas or experiences they've suffered and how it relates to work authorization. Because oftentimes we describe work authorization as incidental or ancillary benefit. But really, for these vulnerable clients, it is their pathway to safety and stability. So many of my clients have suffered domestic violence, been victims of serious violent crime, have been victims of human trafficking, and have been victims of torture and persecution in their home country and are here seeking asylum. And oftentimes, this particular population does not have either the social network, they do not have a history of work or financial assets, and essentially they don't have a safety net to rely on. Coupled with the fact that for the majority of these clients, they are not eligible for public benefits. So when that victim of that crime or that trauma or that persecution is trying to pursue their underlying petition, work authorization allows them the stability and safety to do so. And so what I'm going to just highlight in my couple of minutes that I do have are some of the challenges I see and how some particular systems issues right now directly affects their ability to gain the stabilization and frankly be able to support themselves while they're going through these really lengthy processes to obtain stable immigration status. So I'm going to focus on a couple of areas of the types of protections and how some of these challenges to EAD relates to these clients. I'm going to just focus on people seeking U's and T's. So for U's are for victims of serious crime, T's are for victims of human trafficking, the protections under the Violence Against Women's Act, and asylum. So I'm going to focus on those because within those categories, how someone obtains work authorization is slightly different. So I just want to give you a quick background. For the majority of those cases outside of asylum, EADs are processed by the Vermont Service Center. And for practitioners who do the work I do, that's actually fabulous. They're a very responsive service center. They are specially trained to understand the context which these victims live in and how things like work authorization is so important. For U's and T's, you don't need to file a separate I-765 application in order to get a work permit. It's actually you just need to check off a box on the U and T applications, and once that, that benefit is granted, that status is granted, they automatically issue that. With the Violence Against Women's Act petitions, it's a little bit more complicated. You require an I-765, and I'm going to talk about why for certain types of clients it's more difficult than others. If you have someone who's married to a U.S. citizen, that person generally can file a one-step, and they're only able to get their work permit by filing a 765 in connection with an adjustment of status application, but not with the underlying VAWA self-petition. That's a problem for victims who are married to green card holders because they're not immediately eligible to adjust, and therefore they can't file 765 when they file their application. Why does this matter? Well, there are, as we all know, tremendous backlogs. And so for the applications I just described, you cannot obtain work authorization until you are granted that status. And so what are we looking at? I looked at some statistics and processing times yesterday and my jaw dropped. So, I mean, most of us who practice and have been filing U's, we know that it's just every year the processing times are getting longer and longer. I think several years ago I was excited at 8 months, and right now it's 18 months. So that means when an eligible applicant applies for the U visa, during that entire time, they're not eligible to receive work authorization. And so imagine almost 2 years of waiting. And so you got to also remember what I started out with, but they're in these very vulnerable contexts where they're not eligible for any sort of public benefits. They don't have a social network. So that work authorization is extremely valuable for those clients.
Deepa, can I ask a question?
Yeah.
In the context of the you shifting from 8 to 18 months, is that do you see or do you feel like it's having a chilling effect for people actually using the U program?
No, I don't see that it's having a chilling effect because the underlying benefit is so powerful. It's 4 years of non-immigrants.
Option.
And oftentimes for these clients, there's no other options. Right. They might even have potentially other grounds of eligibility, but they have inadmissibility issues where the U is actually their only avenue. So I'm not seeing a chilling effect, but what it does do is during this process, the majority of my clients who file for U's, and this is from my perspective and my practice, are victims of domestic violence who oftentimes relied on their abusers for all financial for financial support. They often have children. And so when they separate from an abusive situation, and this equally, in my opinion, applies to trafficking situations. So when they're in those situations and they separate, they have no financial safety net. And so work authorization becomes absolutely crucial for them to moving forward. And so that's why that's important.
You generally can't support someone for 18 months. I mean, I don't know of any women's shelters.
Right.
Well, they don't necessarily women's, but it can be
so
male victims too. But they don't. Where can they go? Because shelters don't house someone for 18 months.
Right. So not only do they not generally house any individual for 18 months, many of our clients are not eligible depending on where they are, what their status is at the time, and the type of harm. For instance, while there are domestic violence shelters, the reality of the situation is usually they're emergency-based and no more for 30 days. But for some of the other types of harms, they're simply not eligible. They're not, state, federal-funded shelters. Oftentimes, for example, for human trafficking, I think you're seeing increasing shelters that accept these types of victims, but oftentimes there are no shelters that they're eligible for. Some of and then to move on, for trafficking cases, they used to be adjudicated in 2 to 3 months. I checked yesterday, it's 11 months. And so what we're seeing, you can see, if you look at the charts USCIS publishes, how many applications are pending, and you can see every quarter the applications increasing, and see from the last 5 years how some of those applications have doubled, tripled, particularly with the U context. They have over 94,000 pending applications. That includes principals and derivatives. But what that's leading to are these huge backlogs, which I'm not even going to get into about deferred action and wait lists, because this is limited to the work authorization context, which they do get when they get deferred action. But essentially, these vulnerable victims are waiting. I want to move on to, and so one of the solutions that advocates would propose is that allow for these applicants to have work authorization while their applications are pending, just like when they file for adjustment of status. They're allowed to have a work authorization during the pendency of that application. That would really be a game changer for these vulnerable victims. And one time there's an argument, like especially for the Ts, well, they're processed so quickly. By the time you would get a decision and approval on a T, by the time practically when you get a decision longer for work authorization.
And I do think that the not only the statute but the regulation allows for a issuance of an EAD while it's pending. I think that takes a policy fix. I don't even think you have to do a regulatory or definitely not a statutory fix.
Yeah, I agree with you. I think one of the things, there could be arguments against it because of these huge applicant numbers. I mean, I think there were, like I said, there was over 94,000 pending applications, but there could be some like bona fide determinations, or for instance, when you file a self-petition, there's a prima facie determination that the person on the face could be eligible. You could do the same thing with U's. You could look at the application to some minimum benchmarks and say, issue these notices, right? Issue a BFD or a PFD and say, this would allow them then to file ISOM 65. So that could fix that measure there. We would love to see, advocates around the country who work with these clients would love to see that.
Right, and of course, you should never have to go there. They should be just doing the cases in a timely fashion. Right. And you sort of hate to say, well, let's have an interim thing, which is a second adjudication, because you're not doing the adjudication you should be in a timely manner. So we'll fix it by adding another adjudication. I mean, normally that would be an insane thing to do, but it's not insane if you're taking 18 months processing.
Right. And I think that fix is going to require money. And as we know, there are really limited resources. And the Vermont Service Center has these stakeholder calls, and I believe there's good faith, but without the staff. And we do see spikes. So for the Violence Against Women's Act petition in the last year or so before, I'd been seeing historic long processing times of 15 months. All of a sudden, this year, I just checked yesterday, and it's 5 months. And so we see historic pushes for, they add a lot of staff, which has a whole slew of other issues with the quality of adjudication issues. But, we see that what we do see is these like ebbs and flows with these backlogs that directly affect EADs. Mm-hmm. So I just want to go over a couple other big hot topics for us before we move on to other areas. So another issue I wanted to raise was, you mentioned H-4s, and to the best of our knowledge and other practitioners, under VAWA 2005, there was this provision for battered spouses of certain non-immigrant spouses. So, for example, H-4s. Mm-hmm. To the best of my knowledge, there has been no implementation of this protection. There was a draft guidance memo in December of 2012, and I think, but it's never been implemented. And those have real consequences for those individuals. Mm-hmm. Oftentimes, those abused spouses cannot leave the situation because they absolutely have no legal right to work and no ability to support themselves. And they look at either staying in an abusive relationship or going back to their home country. And this was enacted, this was enacted out of VAWA 2005. Why are we waiting this long for this protection to be implemented? It's just, in my opinion, a matter of someone at USCIS creating a form and making it available and being able to check off that box for those abused non-immigrant spouses. Mm-hmm. So that's something that I think is something that wouldn't be complicated and could be done immediately to implement this protection. Mm-hmm. That's one issue we have. A couple of others, and I know Emmett's going to be talking a lot more about asylum and EADs, but sometimes we encounter inconsistent adjudication of fee waivers, particularly for asylum-based EADs in filing the adjustment of status applications. Mm-hmm. Can't tell you how many times where we have a team of attorneys, and we will file identical applications even for family members, where some fee waivers will be granted and others won't, and it's like a guessing game, and it shouldn't be. There should be consistent adjudication for these fee waivers. And again, we're talking about a vulnerable population. Asylees, they do get work authorization, but oftentimes because of backlogs and that goes to my next point. Sometimes they're issued only for 1 year initially, and they're free initially. But then when you want to file for renewal, there is a fee, and they're quite onerous out of the Texas Service Center in terms of the requirements. Much more onerous than the Vermont Service Center for those other applications I talked about. So what we really need to see is consistent adjudication of these fee waivers, because when you get RFEs, when you get inappropriate denials, as we already addressed at the top, there are real consequences, serious consequences for these individuals who then suffer a gap of time where they don't have valid work authorization. One last topic I'd like to talk about, because it flows directly into Emmett's discussion, is EAD clock stopping when there is a delay attributed to the applicant. And so, a lot of the issues we saw previously for asylees and EADs, I think have been ameliorated by this AOBT settlement. But what I still see oftentimes is I work with victims of torture and persecution who've suffered unmanageable harms, who are suffering post-traumatic stress disorder, who often have really complicated social group based applications where you need time as an attorney in order to adequately prepare, you need time to get experts and evidence. And what we sometimes see is, I would argue, maybe a game that goes on in court where you appear for your first master and you get a court date for the next week. Generally, I have to decline that date. And what happens is that delay is attributed to my client, and then they become ineligible for a work permit. Then it's coupled with, okay, well, I can give you a date for next week, then I can't give you a date till 2017. So your client is there with no work authorization, essentially, during that whole process. And that has severe consequences for our clients. Palma alluded to driver's licenses. So because our asylee clients, they can't use their passport. So I have some clients who are desperate. They can't get basic services. They can't get medical care because they don't have any photo ID. And so this issue, while we again describe as ancillary or it's incidental to their underlying protection or benefit, is actually really, really important to them. So I'm going to turn it over to Emmett to talk about asylum.
Yeah, well, and before Emmett starts, first, thank you very much for those highlights. I think it's relevant to speak to sort of the programs that lead to the employment work or the work authorization eligibility, because they go quite hand in hand. And so particularly to the ones that are directly requiring an adjudication prior to the work eligibility, delays within that have real effects on people and real effects on whether they are in a safe situation and really meeting the intention of the program. So thank you for highlighting those points. As I highlighted before, Emmett Soper with the Department of Justice is here. Now, the asylum clock issue is managed by two agencies and really serves two very different purposes. And I think what Emmett can lend us today is a little education on how EOIR views the asylum clock prior to it sort of moving into the USCIS review, because the nuance between the two agencies' use of the asylum clock is important for practitioners and applicants to understand, because it affects eligibility and affects how the agency has to respond to applications. So I'll turn to you, Emmett.
Sure, thank you. Well, I'll start things off with a little bit of a disclaimer. That is, we don't, EOIR, Executive Office for Immigration Review, we have no actual authority over asylum clock adjudications. I mean, those are exclusively under the jurisdiction of USCIS. So I can talk about what we refer to as our asylum adjudications clock, why we keep it, some basic facts about how it runs. I can talk about that. I cannot, though, comment on sort of USCIS's overarching policies that pertain to work authorization for asylum applicants, when to grant it, when to not grant it, things like that. So Having said that, there are two statutory provisions in the Immigration and Nationality Act that pertain to the timing of asylum adjudications, and they both play a role in these questions. The first one pertains to the time frame within which the agencies are supposed to adjudicate those applications, and that's found at Section 208 D5A3, which provides that the agencies are required to adjudicate applications within 180 days in the absence of exceptional circumstances. So that's one. And the other pertains to work authorization for asylum applicants, and that's found at 208 D2. And that says that asylum applicants are not entitled to employment authorization, but that such authorization may be provided by DHS by regulation, provided that at least 180 days pass between when the asylum application is filed and when work authorization is granted. Both of those provisions refer to a 180-day time frame that has relevance both to EOR's asylum adjudications goal and to USCIS's employment authorization determinations. Those provisions, in turn, are interpreted in the federal regulations at 8 CFR 208.7A2 and 1208.7A2. These provisions are actually worded identically. The first provision is part of the DHS regulations, and the second provision is part of the EOR regulations. And they say that the 180-day period referred to in the statute starts when the applicant files a complete asylum application, and that any delay requested or caused by the applicant doesn't count as part of those time periods. And so to track EOIR's compliance with the adjudications deadline, that's the one in the first deadline in 208 D5A3, we keep what we refer to as an asylum adjudications clock, which measures the time the application has been pending minus any delays that the applicant requests or caused. And then we share that data with USCIS. USCIS, in turn, uses that data in their adjudications of employment authorization applications. So you're absolutely right. Sort of a subtle distinction between the agency's two roles here.
So Emmett, for starting the clock, when does EOIR view an asylum application pending?
So
how is that defined?
So an asylum application is pending once it has been filed with the immigration court or with USCIS pursuant to the federal regulations. There's a little bit of a nuance that's been introduced as a result of the ABT class action settlement litigation. Do you want me to talk about that now, or should I get to that
you can continue.
a little bit later on?
Yeah.
Okay.
So can I ask, when you say you share the data with the other agency, I mean, is this by A number? I mean, this case was filed on this date? I don't really get the picture of how I sort of have a hard time believing you actually case by case notify the agency an application has been filed with the judge.
We send our data to them electronically on all applications
really do?
filed with us. Yeah, and then so when an application for work authorization involving an asylum applicant is filed with USCIS, they pull the data up.
This has to be one of only two instances I know where agencies communicate electronically. The USCIS communicates with anybody else electronically. Just saying.
I know a few more. They're out there.
Yeah.
Then there could be more.
So I'm presuming most people here are at least somewhat familiar with our asylum adjudications clock. I will go over a few general principles. I will, though, first, however, point out that we've provided some pretty detailed information about our clock and how it operates in a memorandum that we've made available to the public. It's up on our website. It's what we refer to as an operating policy and procedure memorandum, or an OPPM. You can find it at the address above, or you can just Google asylum clock OPPM and it'll pop up. Basically everything that I'm about to say can be found in our OPPM, along with a lot more. So I would recommend, for really any sort of question relating to timing of asylum applications when the application is in front of the immigration court, I would recommend referring to that. So EOIR's asylum adjudications clock, it starts when the application is filed, and it runs from hearing to hearing until the IJ issues a decision on the application. When a hearing is adjourned, the clock either runs until the next hearing or it stops until the next hearing, depending on whether there's a delay in the proceedings and whether which party, if any, is responsible for the delay. So just a couple examples. When you're at a master calendar hearing, and this ties into the point that you were making, and then I'll sort of explain generally how it works, and then I'll say something specifically responding to your point. Generally speaking, at a master calendar hearing, when a case is ready to go to an individual calendar hearing or a merits hearing at which testimony is taken, the immigration judge will ask the applicant whether they would like for the merits accepts an expedited merits hearing, then the asylum clock runs. If the applicant declines an expedited hearing, then the clock generally stops until the next hearing. If there's a delay that's attributable to DHS, DHS requests a continuance, then the clock would stop. If there's a delay attributable to the court, for example, you're at a merits hearing and there's just not enough time to complete all the testimony and the case has to be rescheduled, then the clock would keep running because we would deem that to be a delay attributable to the court itself. As a result of the ABT settlement agreement, which I will talk about in more depth in a little bit, where you have a case involving an applicant who's not detained, the judge is always supposed to grant a minimum of 45 days between the master calendar hearing and the individual calendar hearing. That's a lot bigger of a time period than it used to be previously, and that's a direct result of the negotiations that took place to create the settlement agreement. And the idea of lengthening the time period is to get at just the issues that you brought up, to make sure that counsel and respondents have enough time to adequately prepare for the merits hearing. So that is the rule. It's in the OPPM. Judges are supposed to be following it. If there are issues with it, I'll get a little bit later to steps what to do if there's an issue with the asylum clock, if there's something in the OPPM that's not being followed. So those are sort of a few basic guidelines of when the adjudications clock stops and starts in front of the immigration court. Our OPPM sets out what to do if you feel that there is a problem with the asylum clock in a particular case. If you are at a hearing with the immigration judge, you can always bring the issue up on the record with the judge. If the case is pending before the court and you're between hearings, you can write to the court administrator. If you write to the court administrator and you feel the issue has not been addressed, you can also contact one of the assistant chief immigration judges in writing. Just a little bit of background for anybody who doesn't know, we have several assistant chief immigration judges who collectively supervise the courts around the country. And if you look on our website, it lays out who the assistant chief judges are and which courts each one is responsible for. So you're always allowed, if you feel there's a problem with the clock, you've contacted the court administrator, it hasn't been resolved satisfactorily, you can always write to the assistant chief immigration judge, describe the issue, why you think the clock is wrong. They will look into it and you'll get a response in writing. We would ask, however, please not to file motions relating to the asylum clock with the immigration judge. This is also spelled out in our OPPM. We view asylum clock issues as being essentially administrative issues as opposed to merits determinations in cases involving things like whether someone's removable or whether somebody's eligible for relief. So we've instructed judges not to rule on motions relating to the asylum clock, and if they get such a motion, to give it to the court administrator for response. So I would just underline, where there's an issue with the asylum clock, please write to the court administrator as opposed to filing a motion with the immigration judge.
Emmett, can I ask you a question?
Sure.
So what we're seeing a lot of times is that when people are detained, we work with, so when they're detained at the border and then they transfer venue to Baltimore, where I practice, they are given master calendars that are well after their one-year filing deadline. And so, yes, we try to file motions to advance master calendars, but sometimes that does not happen, and so we have to lodge the I-589 with the clerk. And so we want to start the clock.
Yeah.
So what would be, if, what we normally would do is try to file that motion to request that the clock be started. What would you suggest?
Under the APT settlement agreement, as you know, it introduced this process of lodging an asylum application. Our clock does not start. We don't consider an application to be filed when it is lodged. We interpret the regs to mean that an application has to be filed in court in front of the judge as opposed to at the window. However, we came up with this lodging procedure as part of the ABT settlement agreement to get at just that issue. And so even though we don't consider a lodging to be a filing, and even though our adjudication clock doesn't start when an application is lodged, USCIS, under the agreement, treats the lodging as a filing for purposes of work authorization. And they have instructions up on their webpage for cases just like that.
Yeah, there's actually a joint document that has both DOJ and DHS, emblems on it that it go right to that issue. And one of the, we sort of say there's two ways of lodging your application. First, going to the issue of filing in it at a window, and sort of recognizing that if your master calendars are coming up and you have issues of the delayed dockets, for USCIS purposes, that there is a clock.
So if we're getting denials saying that this person's not eligible, what would be our recourse?
So I think the recourse would be you could file a request with the Ombudsman's office. I don't know if that's that if we can't necessarily take every single application, that's not an immediate fix, or that is an immediate fix for a systemic problem. But I think with USCIS, one of the responses in in anticipation of this panel was filing evidence supporting the eligibility of and based on the asylum clock, which I would assume most people that are experienced practitioners would do such anyway. But I think if you're recognizing that your asylum clock for EOIR purposes might not be accumulating time within a calculated data system, but for USCIS adjudication purposes and the ABT settlement, there is eligibility met. You would want to include that cover page that's stamped that says lodged but not filed, and demonstrate that you have met the sort of threshold requirement for the days starting to count. And I don't know if you're still seeing denials after doing that.
I believe a colleague has. I can say that that's our approach for recently. We had some remands come back for the BIA, and it was a client again who I was given a individual for a week after we filed the 589, so had to decline, and then she essentially then had to appeal to the BIA a denial. My client did not have work authorization. This whole process was 3.5 years.
Yeah.
And so what we did was exactly what you said, and I encourage, and that worked in that case for the BIA remand. I think we've had, we may have had some negative results though in terms of what we're lodging.
Yep, and I think our office is definitely seeing those, and we're trying to address it both on the individual case basis, but then also systemically to recognize that I think that both agencies have done quite a bit to coordinate and better explain to the public how they use the clock in different ways. But I think there's always room to improve the process, and that's something that the Ombudsman's office is uniquely tasked with. So.
Thank you.
So you're saying that all of the clerks of the courts have a little stamp that says lodged but not filed, and you take your 539 there and they put it in their little clock?
Your
with the type
I-589.
stamp?
Yes.
I-589, I'm sorry.
Yes, they do. We're required now to do that under the ABT agreement. So each court has a lodged not filed stamp. You take your complete asylum application to the window. If you have an upcoming master calendar hearing, they're required to accept your application as lodged. They stamp it, they give it back to you. You can also do this by mail. Then I believe the current process as far as CIS is concerned is then when you file your 765 work authorization application, you include a copy of the lodged application.
Right. So.
And just incidentally, I will point out, because it's up on the slide, as another part of the ABT settlement agreement is that we are required when somebody lodges or files an asylum application to provide a joint notice that both agencies have cooperated on, explaining clock issues and work authorization issues pertaining to asylum applicants. That's it's referred to as the 180-day asylum EAD clock notice. And in addition to being available in courts, it's available on USCIS's website at the address up there.
Is it available in more than one language?
It is not, I'm afraid, just in English.
Carrie, I think we have a question up there. I don't know if you want to take it or wait till the end.
Oh,
It relates to this particular
sure.
issue. I work at a sanctuary for families in New York, and one of the things that we do is represent individuals who are entering the country seeking asylum. Very similar work to that for Carrie. And the majority of our clients, just because of the delays in our districts, we're not getting, if folks are being apprehended at the border, then they're being released up to New York and New Jersey. We're not getting individual asylum hearing services until June of 2019 now. Those individuals, if they come to us, we know that they have to lodge, and so we fix the exam issue. But folks who are unrepresented, we've seen a number of these people already are going over the 1 year. They're gone through routinely because no one in rural communities in New Jersey. Is UIR thinking strategically about what's going to happen when all these folks get their master gallery hearings in 2019?
We're certainly aware of those issues. I can't go into any specifics. I'm not really sure what the specifics are, but we're certainly aware of those scheduling issues caused by the sort of backlog.
Would there be any way of maybe advising folks upon release from detention that if they're going to be seeking asylum, they should be, I don't know, go to the court and asking for the document that relates to their work authorization? I don't know, getting them at an earlier point by the time that they get their master.
There may be, and we do work with nonprofits who do work with people in detention who are or will be in immigration proceedings. I'm not directly involved with those efforts, so I don't know specifically what we do or what we might do in the future. We're certainly aware of those issues, though. Okay, I just wanted to talk a little bit more about what to do if you feel your clock was incorrectly stopped. So if a case is in front of the court, you can contact the court administrator or the assistant chief judge. If your case is on appeal at the Board of Immigration Appeals, and you feel the clock was incorrectly stopped in the initial proceedings before the immigration court, you can always contact EOR's Office of the General Counsel, where I work. We get a handful of these letters per year. When we get one, we always look into what happened, and we adjust the clock if we think that it's necessary. So that's the procedure to follow where a case is pending in front of the Board of Immigration Appeals. I would add that if you have any comments, any issues at all relating to sort of broader asylum policy, clock policy issues, if you just want to tell us, how things are working in the courts, if you have questions relating to the asylum clock that are not case specific, you're always welcome to contact my office in writing as well. We will always look into things, and we will always get back to you in writing. And that's actually a good way for us to find out what's happening, what's going on, how the clock is actually working for people who are in proceedings. So I'd just like to encourage, to the extent that you notice things that you think should be brought to our attention, I would encourage people to write to the Office of General Counsel at EOIR. I wanted to close by talking briefly about the ABT class action litigation, which we've already talked a bit about it, but this, we usually refer to it as the ABT case. It was a class action litigation brought in federal district court in 2012 pertaining to work authorization issues for asylum applicants. USCIS and EOIR were co-defendants in that case. And following some pretty lengthy negotiations, the parties reached a settlement agreement in December of 2013, which did a few things, a few of which we've touched upon already. For one, people are now allowed to lodge applications at the court window or by mail. As I mentioned before, this is not the same as filing an application, but USCIS, under the agreement, takes the lodging date into account when calculating eligibility for work authorization. And we also, both agencies, as I mentioned, make this notice available. It's on USCIS's website, and it's available in court, in the immigration courts, when somebody lodges or files an application. One other very significant thing that the settlement agreement did was that pertains to cases that have been remanded from the board to the immigration courts for further consideration of an asylum application. Under the agreement, when a case is remanded for further consideration of the asylum application, the time that the case was pending on appeal and on remand is now counted by USCIS for purposes of employment authorization, minus any delays requested or caused by the applicant. That's very significant. Before this time was not counted for purposes of work authorization. It's not included on our adjudications clock because we interpret the adjudications 180-day window as ending when the IJ issues the initial decision, but USCIS does count that time for purposes of employment authorization now. Two other quick things. Immigration judges are now required at the end of each hearing to make clear on the record why the hearing was adjourned. And to get back to a point I made previously, they have to allow, in cases involving non-detained respondents, at least 45 days between the master calendar and the individual calendar hearings. That can be shortened, of course, if there's available space and the respondent requests, but the judge has to allow a minimum of 45 days and can't charge that delay to the respondent. There's some other aspects of the case that pertain solely to USCIS that I won't get into, but those are sort of the main ones that affect applications that are in front of the immigration courts. Last thing I'll say is that we've set up what we refer to as the ABT claims process, under which if you feel that one of the agencies wasn't abiding by certain aspects of the agreement, you can get in touch with us in writing, we'll look into it, and we'll respond in writing within 45 days. There's a form actually that you fill out. It's up on our website. You fill it out, you send it in with usually with a cover letter and whatever evidence is relevant. We will look into it and respond in writing. This is the types of claims that this relates to are, for example, if you tried to lodge a complete asylum application at the immigration court window and they wouldn't accept it. A couple other ones, but that's really the major one. I think that the system is working pretty well. Of course, there are always issues, and when people bring issues to our attention, we always look into them.
Great. Thanks, Emmett. So that was sort of the EOIR side of EAD clock management. When looking at the USCIS side of the asylum clock, I think Emmett highlighted and other panelists highlighted, for USCIS, it's about eligibility for work authorization. So, as identified, the ABT settlement carved out some eligibility allowances, which I think are very relevant and important to include in your filings. USCIS has identified that they look at the totality of the evidence presented in the filing application in addition to the actual data system that they share with EOIR. So I think it's always important to include the evidence you believe is relevant and a part of your applicant's case. And I think certainly highlighting the fact that this is all sort of nuanced and complex processing for a single-page document or single-page application might be difficult for an unrepresented individual. And I think EOIR and USCIS have tried in the last few years to really improve its public outreach, to improve its website postings and public documents to educate filers. But I think there's always room to grow, and certainly opportunities for the stakeholder community to either educate potential applicants, but then also government offices to engage the public as well. we identified with ABT settlement the lodging and not filed. I think it's it's very relevant and important to read that settlement to be sure that you're capturing the right allowances that were carved out for that application. Additionally, every asylum office has a designated POC, point of contact, for asylum clock matters, and you can find that on the USCIS website at uscis.gov/asylum, and there's also walk-in hours that are available. So those are resources that USCIS has put out for the public and for applicants to take advantage of, unrepresented or represented. So I think the agency recognizes that it's a complex issue and at times works very well, but at times doesn't. And so there's definitely customer service engagement where they can. So going back to the person behind the application, one of the issues that's been highlighted throughout the day is with H-4 derivative beneficiaries and EAD renewals. Palma, can you talk to that, of what you've seen within the employment sector of that new program's involvement for EAD eligibility?
I will. I'm first going to back up a little bit. In addition to the resources that you cited on the USCIS website and on the ER website, the American Immigration Council has a wonderful practice advisory from February 5th, 2014, after the ABT settlement, on employment authorization and asylum strategies to avoid stopping the asylum. We didn't talk about directly was the most typical, I think, which is an application for adjustment of status. I want to say particularly because our missing panelist was from the National Benefit Center with a spouse case, what we call a one-stop, which is such an antiquated term because that was when you could go in person and file both applications in one stop at your local office. So when people talk about a one-stop, it's like, no, really, you're putting it in the mail, but that's another. And then you will have other stops later, quite a few. But anyway, one of the things you need to know about that is there's also a clock there, that 90-day clock that we've mentioned is in the regulations. It stops whenever there's a request for evidence. And the most common one of those at the National Benefit Center is for issues with the affidavit of support. So that's something that a lot of people don't realize, and that's because of a 2005 change in policy that the affidavit of support is now part of initial evidence. Not every RFE, request for evidence, from the National Benefit Center stops, well, it's not considered representative. If all of the three applications were filed together, which is quite good. Doesn't always happen with premium processing, when you would think it might because you're paying all the extra money. But technically, premium processing only applies to the 129H, the H-1B application, and it's only expedited for H-4s and H-4 EAD as a courtesy. In other words, if they separate the files and lose them, you're stuck. When you file, so if you're not all in the same packet because the person already has an H-4, for example, that's good for 2 more years because the initial H-1B and the initial H-4 was all filed and approved before there was the opportunity for employment authorization for H-4s. So when you file separately, then you've just got the pure 90-day clock. And there has been kind of a wide variety. I had some of those approved in 30 days. I had some approved in 60 days. I did not see any of those this summer actually get close to the 90-day mark. So I was very pleased by that. The SCOPS said basically they were surprised that they didn't get the number of applications they were expecting. So that may be, maybe they were geared up and had, units ready to handle those applications. They didn't get as many. They were spaced out in a broader, they didn't all come in Memorial Day when they first went online with the program. So that, I think, has been a very successful rollout of a new EAD program. So they're all sitting there waiting for H-4s and not doing changes of status for students, but that's a whole other issue.
So thank you. And, so we've sort of highlighted humanitarian programs, we highlighted some family filings, employment. So once your client has the EAD, once your employer has a work eligible employee, what next? What's the issues that you could encounter for that employee and as an employer or employee? So I wanted to highlight an office that's also within the Department of Justice, which is the Office of Special Counsel for Immigration-Related Unfair Employment Practices. And this is an office that was created to enforce the INA's anti-discrimination provision. And it's an office actually that sort of stands similar to the Ombudsman's office, where it does a lot of robust public engagement and tries to make itself available to both employees and employers to identify worker discrimination, potential discriminatory behavior for a well-intending employer that may not understand how to properly enforce some of the verification programs that DHS requires of them. But then also for employees, as highlighted in the prior panel, employees that believe that maybe the system isn't protecting them the way that they should, or the way that it should. So there's a bunch of handouts. Really, the OSC's website has a lot of information. I also have some handouts up here if you're interested in having some of those for your clients, and for both asylee and refugee issues, for employer regarding I-9 and E-Verify processing, but then also employee rights with regards to what type of behaviors are prohibited by federal law and how they can act and assist. There's also OSC resources. They have a hotline, and they have multiple languages that they can access if your client does not speak English or prefers another language. And there's a worker line and an employer line that can both address the various topics that those callers might have. There's also their website and an email. And so it's a resource that I think is becoming better known and better used by employers and employees as a way to recognize that even after all the application process and the processing challenges and the eligibility hurdles, sometimes you need to have a little bit more support. So that's just one more resource that we wanted to highlight for employers and employees to ensure that the federal laws are properly in place. So with that, I just would like to open it to any questions if folks have them for the panelists or comments from the group. All right. Well, I have a couple questions.
You also didn't do that one. I could do.
Here, I'll just. So Palma, if a person is in a student status, and they also have TPS, are they work authorized? Is that something? How do you identify what their work eligibility is if one has an EAD eligibility and one does not?
The long-established rule, as it were, is that you cannot have two statuses in the U.S. You're one or the other. In this case, if you have employment authorization through temporary protected status, you are definitely employment authorized. And you can continue to go to school or work, and you can go to school and work if you have temporary protected status. Now, you're also considered to be maintaining your status while you're in temporary protected status. So if your country is then withdrawn, the TPS program is canceled, the fact that you were employed while you were under TPS in no way affects your returning to student status. There's been very clear guidance on that you're continued, so you can go back to the status you were in before, or could change to another status if you happen to be eligible for another one, an O or an H or something else. So you're definitely authorized to work if you have the employment authorization through TPS, and it does not affect your status as a student.
Great. Emmett, I think you've identified some of the docket procedures for the immigration judges. One of the things that our office has been seeing is cases that have been administratively closed with the immigration judge, and then having some challenges with USCIS's adjudication process. Looking just at the EOIR sort of view for administrative closures, how does that relate to asylum clock?
From our perspective, if a case is administratively closed at the joint request of the parties, we would stop the asylum adjudications clock on the ground that that's a delay in the proceedings. I mean, the case is still pending, but the administrative closure itself is a delay. So we would stop the clock, which is separate from the sort of policy question of to what extent should somebody whose case is administratively closed or an asylum applicant whose case is administratively closed be eligible for work authorization. And that would be a separate question for USCIS.
Right. All right.
And I can tell you that there's an administrative appeals office decision, very detailed, not published, one that they should publish, which states that if the clock had already run, there was already the 180 days, and the individual that we're talking about, an applicant for asylum who had an employment authorization document, and then the case was administratively closed, that person is entitled to extend that employment authorization. And that's discussed in detail, and there are several courts, circuit courts that have held that, and that's all in this advisory that I mentioned from the Legal Action Center of the American Immigration Council.
Great. All right. Well, I think we're just at 4:30, so that was the end of our panel's discussion. If there are no questions, I'd like to thank the panelists for your participation, and thank you all for holding out as we finish the day. As I mentioned, I have some resources from the Office of Special Counsel if you're interested in collecting those for yourselves or your clients. And I would assume if you have any questions for the panelists, you're more than welcome to come up and speak to any of us. Thank you. Oh, and please turn in your evaluation form for the conference day. There's boxes just outside of the door that you can leave the evaluation form. It's very helpful for us to understand what topics were best received and improvements we can make for next year. Thank you so much for coming to the Ombudsman's annual conference, and have a great night.